question about 155. So we have prepared a list of at least 34 cases overnight where two judges have decided serious issues. Bijoy Emmanuel, Moini Jain, Hussain Ara Khatun. Lordship would like to have a list of it. We'll file a list at the end of it. I'll also get
I'll deal with Malord in my turn. They were on Malord, some other constitutional issues, but there was no request made that these are so wide-ranging implication that better go under 145(3). Some of them are even overruled by the larger. Moini Jain is.
I'll give the list. But what I'm saying is important issues are decided on 14, 18, and I've also included cases where the courts have struck down a statute by two benches. Not case merely because
the statute can be struck down.
Of course. Under Article 14, 19, 304, where important questions of constitutional law are involved, it was heard by a bench of two judges.
No.
So it's not that every issue involving a substantial question of.
No, if a statute is found to be violative of Article 14,
Yes.
on that ground alone it can be.
But they have discussed the scope, like for Express newspapers, three judges, they discussed the entire law of freedom of speech, 19(1)(a), and in Express newspapers, the impact of customs duty on 19 was a completely new point. I'm not saying where this law is settled, they simply implement it. We'll give the list. And as my friend put it, there's a maxim called curiae cursus curiae, lex curiae. The practice of the court is the law of the court. 74 Supreme Court 2 and there's a 53 Supreme Court judgment also that what is the practice in the Calcutta High Court on hearings will be the law of that court. I'll give those to you. Deeply.
But if I may continue with my Lord's permission, just to complete that last part of yesterday's submission on the original intent, but I was at para 2.8 of my submissions on page 1324. But I'll be very quick in this part because this part has been shown to your lordships earlier. I just want to pinpoint the specific areas of the Constituent Assembly debates. I wanted to invite your lordship's attention. Page 1324, para 2.8. Under the draft article 175, my lord, just 2-3 sentences. My lord, if I may start, my lord, with the speech of Mr. B.R. Ambedkar. It was felt that in a responsible government, there can be no room for the governor acting on discretion. Therefore, the new proviso deletes the word in his discretion. My lord, then page over, my lord, only to the relevant part, because this has been read for your lordships. My lord, page 1325, the speech of Mr. T.T. Krishnamachari. But after about 5 lines in the bold portion, that the governor will not be exercising his discretion in the matter of referring a bill back to the house with a message. That provision has gone out of the picture. The governor is no longer vested with any discretion. If it happens that as per amendment number 17, the governor sends a bill back for further consideration, he does so expressly on the advice of his council of ministers. My lord, then the underlined portion below that, my lord. But there is some point of the bill which has been accepted by the upper house, which the ministry thereafter finds has to be modified. Then they will use this procedure. So, my lord, this was contemplated to be for the aid of, my lord, the council of ministers. My lord, then the next speech of Mr. T.T. Krishnamachari. My lord, if my honorable friend understands that the governor cannot act on his own, he can only act on the advice of the ministry, then the whole picture will clearly fall in its proper place before him. But after 2 lines, it is a saving clause and vests power in the hands of the ministry to remedy a hasty action that they might have undertaken or enable them to take an action which they feel they ought to in order to meet popular opinion which is reflected outside the house in some form or the other for this purpose only. This new proviso has been put in. It does not abridge the power of the responsible ministry in any way, and therefore it does not detract from the power of the lower house to which the ministry is undoubtedly responsible. It does not confer any more power on the governor. On the other hand, it curtails the power of the governor for the position envisaged in the original proviso which it seeks to supplant. My lord, then, my lord, page over. My lord, this is one other important fact the lordships may kindly bear in mind. My lord, in para 2.9, I indicate, my lord, that when draft article 143 was being discussed, my lord, which is 163 today, dealing with the governor's discretion. But one of the suggestions, my lord, made was that you cannot say that in the latter part of article 163, that except in matters where the governor is conferred a discretion. Now, if your lordships, this speech has been read out to your lordships. Your lordships recollect, the speech of Dr. Ambedkar. Dr. Ambedkar said, one way of doing it is, here itself we say that the governor shall be aided by the advice of the ministry, except in articles X, Y, Z. But those X, Y, Z articles are to come later in the debate. We do not know what shape they will take. So as and when we reach those respective articles, if we feel the governor has to be given discretion,
We'll revisit this article, but then it was not revisited.
that's correct. So now what happens is when your lordship based the discussion in relation to draft article 143 in mind, where they said that if the discretion has to be conferred, we will do so expressly in those articles. My lord, then when it comes to draft article 175, article 200, in contradistinction, what was provided originally in the draft article was in his discretion. Here, expressly it has been removed. But instead of providing it or for your lordships to inferentially read into it, that this will have a discretion. So first draft article 143, they say, we will say wherever the governor is granted, my lord, may I read just 163 for a minute, my lord, article 163. Right.
So,
Very well, then I'll just skip. My lord, then, my lord, if I may move to the next point. So, my lord, this para 2.9 deals with, my lord, the twin action, where on one hand, in 163, they say that we will provide expressly, but when it comes to article 200, my lord, it was expressly deleted. My lord, then in para 2.10, I indicate, my lord, this has also been shown to your lordships that except in the other articles where express discretion has been conferred, with no discretion being conferred in article 200, my lord, it would not be possible to read in a discretion to the governor. My lord, then 2.11. My lord, this is the last submission on the second proviso. My lord, the second proviso, when it specifically says that the governor shall reserve the matter for the consideration of the president, my lord, where the powers of the High Court may be affected. My lord, that second proviso is actually, my lord, an indication of the fact that the governor normally would not have a discretion. He would be bound by the aid and advice.
we have already
Very
said that.
My lord, then if you
Where the parliament wanted to specifically provide a discretion, it has been provided in the second proviso.
That's right.
Therefore,
But I'm only bringing one other nuance. I understand.
assume that the parliament, the Constituent Assembly did not intend to provide a discretion in other matters.
My lord, I'm making a slightly different nuance. While it was said in the respect of various other articles, including, my lord, Article 200 second proviso, I'm saying the second proviso of Article 200 itself is an indication of
Yes,
the earlier part.
so far as when it affects the powers of the High Court, there is a mandate to the governor that he shall not grant.
Yes, that's right. Obligation. There is no discretion.
I'm sure I'm not able to get my nuance across. If you lordship just give me one more minute, my lord. The point that I'm trying to make is that lack of discretion that is provided to the governor, my lord, is not indicative of a lack of discretion at the governor's hands. It's a lack of discretion at the Council of Ministers' hands, my lord, where they can do something which will abridge the powers of the High Court. Because if the Council of Ministers, who normally will guide the governor on what steps need to be taken, the governor is now granted, my lord, a separate exceptional power under the second proviso saying that here you are not governed by the Council of Ministers' advice. The Constitution enables the governor that other than the regular procedure contemplated under Article 200, where is otherwise bound by the Council of Ministers' advice, the governor here is not bound under the second proviso, even if the Council of Ministers asks him to assent or, my lord, send it back to the House at the most. My lord, he will have to reserve it for the consideration of the president. So the second proviso is indicative of the fact that the earlier part of Article 200, the governor has no discretion. My lord, then, my lord, what I have done for your lordship's kind consideration is,
What are the so-called words that you are trying to locate for the second proviso?
Yes.
For that reason. What is indicated? The governor shall not assent, that's all.
provided that the governor shall not assent to, but shall reserve for the consideration of the president any bill which in the opinion of the governor would, if it
You can
became
say
law.
in the opinion of the governor.
That's correct. So, my lord, when the governor is now mandated by the Constitution that he shall not assent to, he shall not assent to even if he is advised to the contrary by the Council of Ministers.
So his discretion will prevail over the advice of
That's correct. Correct. So where they wanted this to prevail, it was expressly provided. So, my lord, the scheme of Article 200 is, if the constitutional makers felt that the governor anyway has this discretion, it need not be expressly provided by the second proviso separately. The provision is indicative of the lack of discretion in the earlier part. That's the submission I'm making, my lords. My lord, now your lordships may kindly bear in mind, my lord, I'm dealing with the exceptions after this very quickly. I don't need to go into detail. My lord, MP special police case has already been cited for your lordships. My lord, though it arose in the context of 197 CRPC, my lord, the Supreme Court, my lord, in para 33, my lord, a specific question fell from the court. Is the governor bound by the advice of the Council of Ministers in a statutory discretion area, like section 197 CRPC? But 197 CRPC also, my lord, this honorable court holds that ordinarily, but even in that space, the governor is bound by the aid and advice of the Council of Ministers, except in cases where the Council of Ministers itself may be disqualified on account of inherent bias, or, my lord, where the interests of the chief minister or the ministers are concerned. My lord, that is at para 33. My lord, I don't need to show this to your lordships. My lord, what I have done at the foot of the page, but after indicating the, my lord, the carve out areas made even in a statutory space at page 1327, but this was also mentioned to your lordships. Vaishno Devi, my lord, Shrine Act confers powers on the governor separately statutorily. My lord, similarly, my lord, there are various state statutes which, my lord, provide that the governor shall act as the vice chancellor. My lord, there the Supreme Court has, chancellor, I'm sorry. My lord, the Supreme Court has taken a view that he operates in his capacity as a chancellor.
That has also been argued.
That's it. My lord, only thing, my lord, your lordships may kindly bear in mind is now, my lord, that there is a case where your lordships have seen this possibility of a inherent bias that may be available. Some of the cases that come up, and my lord, those are cases, I'm not touching on the facts of this case, but these are cases that have been decided by this honorable court. When Tamil Nadu wanted to make an amendment to the act and remove the governor, my lord, as the chancellor, replacing him with the chief minister, the governor, my lord, sits on that bill or sends the bill for consideration of the president. Your lordships may have to consider, since your lordships are acting in an advisory jurisdiction, which is much wider, I'm sorry, but whether a governor who is otherwise conferred, my lord, this separate power under a statute, if the legislature is making a law wanting to remove it, is he inherently biased in trying to sit on that bill because he will continue to?
That's not a question for consideration.
I'm not that.
We will be answering what has been referred to as not
Very well.
Not any hypothetical question.
Very well. My lord, then I move on to, my lord, if this is the original intent being absolutely no discretion in the governor, my lord, then should the courts, my lord, in the few areas that exceptions have been carved out are areas where the governor may not have the aid and advice of the minister if the ministry is not formed, or where, my lord, the ministry itself may be biased in, my lord, in the matter of, my lord, calling upon someone to form a government in case of a fractured verdict, those kind of situations where the governor may not otherwise have the benefit of, my lord, what is constitutionally looked at as aid and advice of the ministry. But other than, my lord, those carved out areas and special discretion conferred areas, my lord, if your lordships have to now read into Article 200, as, my lord, is suggested, my lord, by some of the council, that certain discretion would have to be read into, because, my lord, there may be situations where the governor may have to think, may feel, my lord, that it is better to have a cooling off period, or, my lord, some arguments were made that not taking a decision also could be a decision. Now, my lord, lordships are looking at a possibility. My lord, I'm only dealing with these arguments of a possibility if a lordship's doing this. Lord, lordships may kindly, my lord, notice one very important fact. At the time the constitution was made, my lord, the union in that sense, my lord, was not formed with the definiteness that we have today after 75 years of the union continuing to be there. My lord, there was a lot of tension and worry with regard to, my lord, this forces that may work towards fissiparous tendencies. So, my lord, the Indian constitution wanted to have a slightly stronger unitary center. So when it was having this stronger, slightly stronger unitary center, back then, they still felt, while we are concerned with these issues, there may be still be certain areas that can be left exclusively to the state. Now, in the areas that are exclusively left out to the state, at that point of time, they did not want the governor to have a discretion. Now, your lordships are, my lord, looking at the law after 75 years. My lord, when such tendencies are no longer as concerning, my lord, they are no longer as imminent or possible. My lord, the necessity of trying to dilute a provision against the state's interests and in favor of the governor, my lord, the necessity may actually be lesser today my lord, because, my lord, the Indian Union, my lord, by the sheer length of its existence, has gathered strength from time to time. So when your lordships look at, my lord, the situational difference between the time the constitution was made, when they felt we can have a governor for certain oversight functions, to ensure that there are no fissiparous tendencies. Even then, if the constituent assembly makers felt the governor's powers need to be restricted, there is no reason, my lord, to expand that role after 75 years is my submission. My lord, then what I quickly do, my lord, in my para 2.14, my lord, the other grounds that I am placing for your lordship's consideration as to why, my lord, this purposive interpretation for expanding the governor's discretion may not be correct. My lord, I indicate this will be at odds, my lord, with expressly removing from Article 200 in his discretion. My lord, reading in a discretion in Article 200 would not align with the constitutional provision of Article 163, which requires discretion to be expressly conferred. Only cases where the Honorable Court permitted a discretion to the Governor and President are situations where the aid and advice of the Council of Ministers may not be available to the high constitutionally functionaries in view of a self-interest or inherent bias of the Council of Ministers or the non-existence of the Council of Ministers immediately after an election or in a case of a fractured verdict. My lord, this is another very important submission I wish to make, that though vertically different, both the president at the union level and the governor at the state level are part of a Westminster form of democracy. The governor's role under 200 would be similar to
Already argued yesterday only.
My lord, the only point, if I may add, my lord, in terms of an extra feature to this is, my lord, when your lordships look at, my lord, the areas that are carved out, the areas are separate, my lord, for the union and for the state. But in the democratic form and setup for the union, it is no different, my lord, from the democratic form and setup for a state. So if for any reason, my lord, Article 200 can be construed to mean that the governor can have the discretion to withhold or sit on a particular bill for allowing it to cool off, my lord, it would have a similar ramification for Article 111, because the president can then equally do. It cannot be that the democratic setup for the union, my lord, where there is separate discretion, my lord, wherever they,
That has already been argued.
very well.
That the role of the president and the governor are almost similar at the center and the state.
My lord, then I move, my lord, to my lord, page 1329. But again, these are the three options which, my lord, in my respectful submission are available to the Council of Ministers. My lord, I won't read through, my lord, the three exceptions except, my lord, 3.13. My lord, these have been noted both in the Constituent Assembly and also, my lord, this Honorable Court's judgments, that there may be exceptional circumstances, my lord, where the Assembly may want to reconsider. My lord, in 3.3, my lord, I have referred to Shamsher Singh's judgment, my lord, at page 1330. This para 118 is a submission that I was just making prior to this. My lord, if I may just read this with your lordship's permission. The argument about the oath of office of the president to defend the constitution is sometimes put forward by anti-ministerialist advocates. Yes, he defends the constitution not by denying its spiritual essence of cabinet responsibility. Indeed, he subverts it that way, but by accepting as his constitutional function what his responsible ministers have decided. Can a judge in fulfillment of the oath of office ignore all binding precedents and decide according to the ad hoc dictates of his uninformed conscience? Tribhuvan Das case answers the point in the negative. If every functionary who takes the oath by the constitution interprets according to his lights, this solemn document would be the source of chaos and collision, and the first casualty would be the rule of law. Such mischief cannot merit juristic acceptance. My lord, this para 123, 124, I'm skipping. My lord, this is the history immediately after the constitution, my lord, when the Hindu Code Bill was enacted. My lord, in the bold portions, my lord, your lordships would find, my lord, also at page 1331, just Sir Aladi's opinion, my lord, that throughout the, my lord, clarity, my lord, these legal luminaries had was, my lord, that the governor would have no discretion. My lord, page 1332, my lord, 3.4 summarizes my submission on this point. My lord, my contention for your lordship's consideration is what is made available for the benefit of the executive for the rare situations cannot be encroached by the governor. My lord, in Nabam Rabia, my lord, this your lordships noticed, my lord, that it would not be, my lord, presumed or envisaged that a democratically elected council of ministers giving advice may be acting detrimental to the interests of the nation. Lord, what was presented, my lord, in terms of argument was if the ministry were to do something that is against the interests of nation. Lord, that is something, my lord, that is normally not presumed, but if a particular fact situation emerges, my lord, that would be dealt with in terms of the constitutional provisions. My lord, then reference to the president, my lord, was broadly already touched upon yesterday, so I can move very quickly there. My lord, Mr. Datar had argued this, but my lord, something very important for your lordships to consider is at para 3.9. My lord, the Sarkaria Commission, Lord, notes this as a necessary channel. Lord, if I may just read this part. The constitution makers noted that articles 200 and 201 are also necessary in view of clause 2 of article 254. This needs a little amplification. Matters enumerated in the concurrent list are of common interest to the union and the states. On the basic aspects of such matters, legislative uniformity throughout the country is desirable. However, if Parliament occupies the field of concurrent subject, the power of state legislature to enact a law on that subject is in variance with the union law is practically taken away. This results brought in by the operation of the rule of repugnancy contained in clause 1 of article 254. Nonetheless, peculiar conditions, problems and practices relating to that subject in a state may need regulations and remedies quite different from the one provided in the union law. In such a situation, a legislation of the state legislature making provisions suited to the peculiar conditions in the state, though inconsistent with the union law, can be saved from invalidation on the ground of repugnancy if, having been reserved by the governor for the president's consideration, it receives his assent. Thus, articles 200 and 201 provided a necessary channel through which clause 2 of article 254 operates to save the powers of the state legislature from being unduly abridged by the rule of repugnancy. My lord, on the aspect of presumption of good faith, my lord, I have already made my submissions yesterday. So, my lord, I'll skip it, my lord, in the interest of time. My lord, only, my lord, at para 3.14 and 3.15. My lord, normally, a lordship recollects, my lord, if it is reserved for the consideration of the president under article 200, under 201, it goes before the honorable president. The honorable president, my lord, would have the power to ask the house to reconsider and send a message. But if it is sent back, it is again presented, my lord, before the honorable president for consideration. It does not say he shall mandatorily assent. And my lord, there's a good reason for that. Now, when the president does not grant assent, my lord, now typically, my lord, these situations arise when there is a conflict. My lord, the center makes a law throughout the country. A state in a particular geographical area may want to make a slight departure. My lord, it sends the bill to the honorable president, my lord, for the purpose of consent or approval. If the approval is granted, my lord, these provisions of the State Act will take effect within that geographical limit. But if approval is denied, my lord, then those central law provisions will continue to operate. My lord, this is a net effect. But my lord, when the bills are sent, my lord, the president as a practice either declares, my lord, that assent is being granted or assent is being withheld. It would not be kept pending. But well, the honorable president may have taken time. They enable the state to know that assent is being withheld so that, my lord, the state can then work out its affairs. But yesterday I had mentioned, my lord, suppose if my lord, lordships looks at this as something that is likely to arise, my lord, because that is the anvil of your lordship's consideration, not purely hypothetical. Several acts, my lord, may be in a particular state area or it may be in a concurrent area. If a special law is made, my lord, for protection of women, my lord, lordships looks at this situation. It then says in relation to any offense relating to women, anticipatory bail may not be available. Now, this may be, my lord, repugnant to section 438 old of the CRPC. Now, this provision, for it to become effective, it may have to come up, my lord, for consideration before the president by reference. If the president were to grant approval, my lord, then that non-application of 438 would come in relation to this other law made by the state. If the president were to deny, I'm giving a very simple example. If the president were to deny, then 438 bail provisions would continue to operate. But assuming either situation, approval is granted or approval is not granted, all the remaining provisions, my lord, in relation to protection of women under a special law made by the state would otherwise be operative. It may just be this one part which may need the consent of the president. So, my lord, if this is granted, it operates one way. If it is not granted, it may operate in a different way. But if the bill is kept pending without, my lord, saying whether it's assented to or non-assented to, the bill can never become the law. My lord, therefore, my lord, what I have also,
What do you want to, what is your proposition?
no, my lord, the proposition I was making was that when a bill is sent to the Honorable President for consideration, while it would be within the discretion of the President in relation to certain subjects where, my lord, consent approval may be granted or may not be granted, there has to be a declaration indicating whether assent is being granted or assent is being withheld. And in convention, my lord, the President always, my lord, makes a declaration saying that assent is granted or assent is withheld. It can never be, my lord, a constitutional black hole that a bill remains pending without.
Doesn't work like that. 250. We are still in the realm of 200 and 201.
My lord, 201.
201, when the law is not made. Once the law is made, operation of 254 will come in. If it is in conflict with central law, it's null and void, subject to sub-article 2. The law is made, 254, it's law. That's why, see the provision 254 say, if the provisions of a law, that is, there is a law already. So 254 won't apply here. We are in the realm of making of law. At the time of making of the law, the power of assent, the power of withholding, the power of grant. So it's in a stage where law comes into operation.
My lord, there may be two ways of looking at it. My lord, I understand what's falling from the Honorable Bench. One is when the bill is made, if, my lord, the Council of Ministers feels that some of these provisions of the bill may be repugnant and therefore may not be operative unless the President's consent is obtained. At the bill stage, my lord, it can be referred under 201. If 201, the President grants approval, then it becomes a law. 254 will not make it repugnant. But the other way of doing it is the state legislature can request the President to grant assent, make it a law, and then because repugnancy will make the other provisions unworkable, request the governor to send that part of, my lord, but once a law is made, it might be difficult, my lord, for it to be sent to the President thereafter. So, my lord, in my understanding, subject to correction, at the bill stage, my lord, usually 200, 201, it goes before the President. If the President grants, my lord, approval, then, my lord, it becomes a law. Equally possible, my lord, I'm dealing with it in the justiciability part of my submissions, that the President may, after being advised, my lord, by the Union Council of Ministers, say, no, we want to have a uniform policy throughout the country, not in a matter like Essential Commodities Act. We are not agreeable to this state having a separate, my lord, legislative environment in a particular geographical area. So if the President refuses on the advice of Union Ministers, my lord, then the central law will continue to operate by virtue of 254. My lord,
What you have suggested in 3.13 to 3.15 is inconsistent with what has been argued from your side.
no, my lords. My lord, yes.
Probably study you are not here, that's why. But
No, my lord, if I
you
may,
are insisting for a formal declaration, the argument was otherwise. We are only pointing out that from your side. The argument was that there is no requirement, there is no concept of a formal declaration.
Formal declaration of withholding of.
Yes.
correct. Yes, my lord. Some of the states have made that submission, but my submission
You have
is,
completed your 45 minutes.
my lord, another 10 minutes I'll finish, my lord.
No, but then we have to.
Yes, my lord.
We have
No,
to.
just 10 minutes. I'll very quickly run through this. My lord, page 1335, what I have done, my lord, I'll not read this now, note for your lordships. My lord, what I have done is this power under Article 200 and 201, or my lord, the provisions would have to be operated, my lord, in relation to the three lists separately. If it's a union list, my lord, the union list, Article 246(1) itself says that the power to legislate is exclusively vested, my lord, with the Parliament. So state cannot make a law in relation to union list. So, my lord, if a bill is passed by the state legislature in relation to a union list, my lord, there would be no power available to the state legislature. It's ipso facto invalid. It will be void ab initio. If needed, a court will declare it to be invalid. Now, this does not require the governor to exercise discretion either to send it back to the House or send it, my lord, to the President for consideration, because the President also cannot grant consent for making it valid if it is entrenching into list 1. So if list 1 is something that does not require this method of referring it to the president, it will not be applicable. My lord, if it is a state list, exclusively reserved, 246(3), exclusively reserved for the state, my lord, the union parliament, my lord, ordinarily would not have any power, my lord, to legislate on those particular areas. But what I have done, my lord, at page 1336, my lord, I have indicated, and I'm not reading this, my lord, that the constitution itself makes provisions that whenever, my lord, the constitution wanted the power of the state to legislate to be subject to the union's power to legislate in legislative field areas, my lord, there are a series of articles which my lord's entries, my lord, at page 1337, where in list 2, my lord, the legislative field itself is made subject to the union's power to legislate or subject to laws made by the union in this particular behalf. So legislatively, while they carved out certain area for the state, within the carved out area, my lord, they also had certain caveats with regard to where the state, my lord, the center can come and legislate. If it is otherwise left to the state, my lord, legislatively, it is for the state legislature to make this law completely on its own. If such a law is made, the governor cannot sit in judgment and say this is either not desirable or the current circumstances do not make it feasible for having this particular law at this point of time. There is no point of referring it to the president under Article 201 in relation to a state subject, because the president and the union also in the executive sphere have no power to stop a state from legislating on a state subject. My lord, the constitution was mindful that there may be situations when the union parliament may have to be given power to legislate on state subjects. My lord, at page 1338 onwards, my lord, Article 249, 250.
When some of the states make a request jointly.
Correct. My lord, also, my lord, Article 250, my lord, if proclamation of emergency, 252, when two or more states request. My lord, also, my lord, 253, to giving effect to, my lord, any international treaty. My lord, I have set out all these articles in my note. Now, this enables, my lord, that the parliament in its legislative space can make a law in respect of a state subject area. So if parliament, my lord, can do it, it may do so, and it will be for a limited period of time. The constitution was mindful, my lord, in which circumstance it will extend for which period of time, unless, my lord, it is where more than 2 states are asking for it to be done, or the council of states by 2/3 majority requests the parliament to do it for entire India. So, my lord, if in the parliamentary space, legislative space itself, if the center cannot, my lord, infringe on the state's rights to legislate, in list 2 subjects, my lord, my respectful submission is the governor, my lord, either cannot withhold for the purpose of reconsideration or send it to the president. My lord, the only other area would be, my lord, the concurrent list area. To avoid this repugnancy, I've already made my submission, my lord, that this concurrent list area, it would be, my lord, at the request of the Council of Ministers. Even if the governor were to find, Council of Ministers thinks, my lord, it is not entrenching into any central subject area. The governor were to form an independent mind that this may entrench, it may need consent. Lord, he is not sitting in judgment on the legislature's views or wisdom, because he would then have to give assent. If it has to fail, it will fail on the anvil of, my lord, judicial review proceedings that may come up before the court. So for all the 3 lists, when your lordships were to look at it separately, but Article 200 does not enable the governor to either withhold assent for the purpose of reconsideration or sending it to the president. Sending it to the president, my lord, the governor cannot, as I use an expression, my lord, extra constitutional advisor to the state legislature. When the state legislature says, no, it doesn't, my lord, trammel into the central government's legislative sphere, say that, no, I think it does, and refer it to the president. My lord, then justiciability is one last aspect very quickly, my lord, I'll touch upon. My lord, page 1342, my lord, when a bill is sent to the president in relation to, my lord, a concurrent list area or the other provisions of the constitution where the consent of the president is needed. My lord, if the president, my lord, feels on the advice of the union ministry that it is not desirable, my lord, judicial review in my respectful submission is permissible. Because what happens, my lord, if the president were to grant assent to state A for an identical provision, but were to say, I will not grant it to state B for an identical provision, my lord, then it would touch upon the aspect of discrimination. In a judicial review space, my lord, the court may interfere with it. But on justiciability, suppose, my lord, the governor were to say, no, we feel we need to have a uniform policy. or the conditions in this particular state are not enabling the union to have the confidence that there can be a departure from the central law, my lord, that on the fact situation would be dependent upon those factual situations where justiciability may be difficult. So it cannot be, my lord, one common situation where it is not justiciable. Judicial review is permissible. Justiciability depends on a fact to fact case and a situation to situation basis. But I have just made this submission in 3 parts. My lord, last submission, my lord, on timelines. My lord, it's already been covered, but I'm only submitting, my lord, that in terms of your lordship's advisory jurisdiction space. My lord, since the my lord, the presidential reference has been made with specific questions on this point. My lord, if your lordships were to form a clear opinion that this has to be done with expedition and this is to be done within a particular time frame, my lord, that is, as I indicated yesterday, your lordship's view of how time frames or whatever time is a reasonable time for the exercise of discretion, that would still be your lordship's advisory opinion. But that advisory opinion, my lord, in my respectful submission would be binding on the president and instructions would have to go to the governor. My lord, only 2, my lord, yesterday I had mentioned about this judgment. I'm not reading it. If my lords would want to know, make a note. My lord, in that special references case, 19, my lord, this is at volume 5.9, page 3661. My lord, just 3 paragraphs, my lord, I'm requesting your lordship's attention to.
Where have you referred to in your note?
My lord, this is there, my lord, in 6.1. No, my lord, this is not a part of my note. I had referred.
Volume?
Lord, volume 5.9.
Page?
Lord, page number 3661 is a citation, my lord, of 1979, volume 1 SCC 380. Lord, just 3 paragraphs, my lord, I am requesting your lordship's attention to. I am not reading it. Para 21, para 32 and 34. My lord, this 32 and 34 have not been read for your lordships.
On what issue?
My lord, this is with regard to, my lord,
Timelines.
para 21 is on a bill that is yet to be made. Para 32, 34, my lord, deals with how, my lord, there will be no encroachment into a legislative space by your lordships. If your lordships were called upon to render an advisory opinion and your lordships render an advisory opinion. So today, Article 200 and 201, apart from timelines, your lordship's opinion is sought on whether there is a discretion available to the governor, whether the discretion available to the president, in what measure is the discretion available. My lord, questions are also asked, are they justiciable? My lord, then the last of the questions is, are there any timelines that would be governing? So my lord, my respectful submission is, staying in the space available to the president and the governor under Article 200 and 201, they are seeking your lordship's opinion. Since they are seeking in the space available to them, at their invitation, it is fully just and open for your lordships to give this opinion, which might be binding on them in terms of, my lord, your lordship's review orders. My lord, I'm grateful.
Thank you.
My lord, I had mentioned about that notes to the Constituent Assembly. If I may just give the page number, it's 9312. The relevant part I've already extracted in my note. But just one last submission before my friend takes over. My lord, we have had tremendous assistance from the nodal council, but I can figure out, my lord, with the quality of assistance they have given, there have also been a lot of costs they have personally incurred, because all the volumes being filed into the court are being filed by them at their expense. And when we offered to pay costs, they said no, unless there is a, my lord, a formal order, it would not be possible for us. Lordships may.
Yes, my lord, I can vouch for both the nodal council of other side and my council, my lord. It is, my lord, a labor of love, my lord. Nobody would like to charge. It's an assistance to the court, and it's, my lord, and
No, not fees.
even expenses also.
Why?
Your
Volumes and printing of so many volumes.
That's all right, my lord. It's an honor to be a nodal council before the highest constitutional court of the country. And the amount also may not be more, and I'm speaking for.
It can be distributed by the state and all the governments.
My lord, I undertake the responsibility. Your lordships need not, my lord, bother. It's a small thing.
No, we'll.
One council's appearance can bear the expenses. What is the problem there? Why should even this be? Mr. Sibal is there, Mr. Reddy is there,
I take the
Narasimha
responsibility.
is there, Dr. Singhvi is there,
No need.
Mr. Mehta is there.
Lord, I am taking the responsibility for the
I'll
expenditure
bear the
of
cost,
court.
my lord, on this side.
Yes.
No, this side, that side, I'll take the
I'll
responsibility
bear
with.
it on that side also, no issue.
No. I know you, Mr. Symbol is.
As far as the nodal council this side, But
No,
I
Mr.
myself have
Sipal is
written
very
to Tamil
generous,
Nadu government
but
to sanction
I
and
would-
pay.
No, don't, let's not get into this.
Yes.
May I
My lord,
please-
that, my lord, I'll take care of, my lord, for both sides. Your lordship need not bother. But it's very kind of
Just check.
Mr. Reddy, my lord, to have flagged this issue. That's all.
No, if you just look at my note, it is in volume 2.13.
He's appealing for the state, so.
Street, I have to be heard first.
But what are you going to argue? If you are going to toe their line, then we will not listen you from this.
No, we have certain different points. Your Lordship kindly see three provisions of the Constitution. Article two
We
forty-four.
we are going by the sequence.
Let him pause the states and then only the intervener.
I have something to say, my lord. I am not objecting to anybody arguing. But if your lordships are permitting even, my lord, strangers, my lord, to the issue being argued, my lord, I would personally feel, my lord, that let Mr. Wilson also have his day, my lord, for 10, 15 minutes. He at least represents a political party which has a government in one state.
Grateful
But
to my.
individuals who have nothing to do are coming before your lordships and are, my lord, getting your lordship.
Lordship, individuals have to do very much,
My learned friend.
and we can say in this constitutional.
My lord, you have right.
Eventually, the citizens won't get hurt while this political battle goes on to an.
No, nothing like that. Lord,
No,
we
but
have-
there are no-
Lordship,
there is a-
constitution, the document will define the politics
One
of the
minute,
country.
Mr. Sharma, 1 minute. 1 minute, Mr. Sharma. Don't raise your voice.
No, sir.
We'll grant 10 minutes each.
Yes, oblige.
Yes.
Omelette, Lordship.
Kindly see, my lord.
My lord, stranger in the sense, my lord, this is, my lord, state governments, etc., etc. My lord.
Let it, it's okay.
Therefore, my lord, it was my duty, my lord, to say that if others are hurt,
No, we are-
Mr. Wilson also.
We are going to hear Mr. Wilson also. Because if you are going to permit the other interveners, then.
Therefore, my lord, he could not have said it again.
And particular-
Therefore, I am saying.
And particularly when the live streaming is going on, so.
No, my lord, no.
Many of the arguments are only for the sake of live stream. If we stop the live streaming.
Crowd will listen. My lord, I reserve my response, my lord, outside the court, my lord. But I have a very good response.
Your Lordship, the Article 244 of the Constitution, my lord, kindly see, because tribal
You are
area.
appealing for Meghalaya.
I'm appealing for Meghalaya, state of Meghalaya, my lord. Because there are certain unique features in sixth schedule and Article 244 conferring certain powers to the governor, my lord, which will have bearing, my lord. Two forty-four, Article 244, sub Article 2, my lord. The provisions of the sixth schedule shall apply to the administration of tribal areas in the state of Assam, Meghalaya, Tripura, and Mizoram, my lord. So this Article 244(2), my lord, leads to sixth schedule, my lord, and sixth schedule, your lordship will see certain powers have been given to the honorable governor, my lord. Kindly see the sixth schedule, my lord, and more particularly paragraph 3 of sixth schedule, my lord. The regional council, paragraph 3, my lord, regional council for an autonomous region in respect of all areas within such region, and district council for an autonomous district in respect of all areas within district, except those which are under the authority of regional council, if any, within the district, shall have power to make laws with respect to items, my lord, are given. Allotment, occupation, use, and setting apart of land, my lord, that is item A. Then B, management of any forest. C, use of any canal, water. So these are the subjects, my lord, and kindly see sub-para 3. All laws made under this paragraph shall be submitted forthwith to the governor, and until assented to him, by him, shall have no effect. So the laws made by district council, my lord, are required to be placed before the governor. And this provision, my lord, paragraph 3, subparagraph 3, is not similar to Article 200, my lord, where the governor has three options: assent, withhold assent, and refer it to the president, my lord. In respect of these subject matters, my lord, governor will act on the aid and advice of the council of minister, either to give assent or not to give assent, my lord. There is no question of reference, my lord. Here, so my submission is, my lord, wherever the constitution wanted to provide the power to the governor to either grant assent or not to grant assent in unequivocal terms, it has said so.
That has already been argued at least
Yes, my lord.
1 dozen times. I don't know.
So
If you want to add something new, you may add.
yes, my lord, in the context of paragraph 3, my lord, because in paragraph 3,
Paragraph 3 is not for consideration before us.
yes, my lord, so
We are not, we will be answering only what are the questions which are referred to us.
yes, my lord, and paragraph 9, where the governor is
This,
exercising,
that provision is not for consideration before us.
my lord, what,
We have to answer what is referred by the Honorable President to us.
yes, my
We,
lord.
we can't open a Pandora's box.
No, my lord, what I'm trying to submit, my lord, is in the context of Article 200, my lord, if you also will see the Article 200 talks about a marginal note assent to bill. If you lordship will kindly see Article 200, it's the marginal note is also a key to understanding
Yes,
the.
for interpretation.
Now, your lordship kindly see the
When
marginal.
when the provisions of when the text of the article is very clear,
Yes, my lord.
do we need to go to the margin?
No, because what the issue
No.
which,
It's an additional aid.
yes, my lord, it's an additional aid.
When we cannot interpret the text as it is.
Yes, my lord. Now, what my submission is, my lord, this aid is required to be.
What is the first principle of interpretation?
The first principle of interpretation is that the text is clear, my lord, then we'll have to go by the text, my lord. Now, the question which is falling for your lordship's consideration is that whether assent to bill has got three options or one option. Now, because if your lordship will see the marginal note of Article 200 is assent to bill. The marginal note is not saying consideration of bills, my lord. So the two other options, my lord, two other options, withholding the assent and referring it to the, or for reservation, referring the bill for consideration of president, my lord, are also, in my humble submission, my lord, are relating to the issue of assent to bill. Because this is in.
So what is your proposition?
My proposition is that the Article 200 provides for one option, that is assent to bill. And why do I say so, my lord? Is the reason is, my lord, that the issue, my lord, he assents to bill or he withholds the assent. Now, withholding the assent is for the purpose of formulating the message to the assembly, my lord, and after the message is sent to the assembly, then again the governor has no option but to give assent. So the marginal note, my lord, assent to bill, that is the only.
That is what everybody is arguing, that
No,
he has no other option
yes, my lord.
than to send it to the legislature with a message.
Yes, my lord.
And after that, if the legislature again passes the bill,
Yes, my
he
lord.
has no other option than to get grant action.
Yes. So then, placing my argument forward, my lord, because if the governor had three options, withholding the assent, my lord, it is part of the larger.
So according to you, also, the withholding is for a limited period,
Yes, my lord.
which enables him to send the bill along with the message to the legislature.
Yes, my lord.
And after it comes back from the legislature,
Yes, my lord.
as it is, then he has no other option than to.
So assent to the bill, my lord. So then this is also an assent only to the bill, my lord.
That's the integral part of the assent only.
This is.
It's a comprehensive this thing.
Yes.
Assent first exercises well and good, otherwise second and third are also part of granting assent later on
Yes, my lord.
by following that procedure.
Yes, my lord.
Either reserving it for the president or sending it back to the legislature.
I'm grateful, my. This is my precise argument.
Because of the marginal note that assent to bill.
Yes, my. So,
Assent to bill is the very essence of the provision,
yes, my lord.
not withholding of it.
Withholding or consideration of bill, my lord, also, because the marginal note would have said consideration of bill. But marginal note is saying assent to bill. So in my humble submission, it is a key to understanding these three aspects of the matter, my lord. So this is on the assent to bill, my lord. And my lord, if your lordship will see the second part of the Article 200, my lord, because if lordship will, the reference to the president also, my lord, a reference to the president. And there are three aspects, if your lordship will notice, in the first proviso of Article 200, the expression used is as soon as possible. But in case of Article 200, my lord, no such 201, no such exigency has been attached with the president to issue direction to the governor to return the bill. As soon as possible, my lord, is not mentioned in Article 201. So there is, my lord, so far as the reservation of bill is concerned, my lord, to the president, no such expression is used, my lord, regarding as soon as. Now, my lord, the point which I am trying to make, my lord, that as soon as the expression used as soon, in certain cases, my lord, for example, in 201, your lordship, kindly see 201. 201 says, my lord, when a bill is especially second proviso, my lord. 202 provided further that governor shall not assent but shall reserve for the consideration of the president any bill which in the opinion of the governor would if it became law so derogate from the powers of the high court so as to endanger the position which the court is of the opinion court is by the constitution designed to fill, my lord. Now, in respect of this aspect, my lord, if your lordship will see, when a bill is reserved by the governor for the consideration of president, president shall declare either that they assent to the bill or withhold assent therefrom. Here, my lord, message is in proviso, provided where the bill is not a money bill, president may direct governor to return the bill. Here, there is no use of expression as soon as. Whereas in the case of article governor, my lord, expression used is as soon as, showing the expediency in matters which are not reserved for the consideration of the president. So there are certain areas, my lord, there are certain provision which can be reserved for the consideration of president, my lord. Articles are, my lord, which are Article 31A. I will not read those articles, my lord, because those have been placed. 31A, my lord, your lordship will kindly see 31A. And proviso particularly, my lord, because under these articles, the bills have to be reserved for the consent of the president. Article 31A, my lord. Proviso, my lord, provided that where such law is made by the legislature of a state, provision of this article shall not apply thereto unless such law, having been reserved for consideration of the president, he has received his assent. So 31A, my lord, then 31C also, my lord. Provided where there such law is made by, it's a, then, my lord, 254(2) also, my lord, if lordship will kindly see 254(2), because the governor, if it is taken, my lord, is bound by the aid and advice of council of minister, and the bill is passed by the legislative assembly, it is passed by the party which is in power, my lord. So if there is no discretion vested with the governor on this issue, my lord, 254(2), then the advice would by the council of minister to the governor would be not to place it before for reserve the bill for the assent of the president, my lord. So therefore, certain exceptions have been carved out, my lord, particularly 200, Article 200 proviso 2, my lord, and that 31A, 31C, and 254(2) also, my lord, where a law made by the legislature of state with respect to one of the matters enumerated in concurrent list contains any provision repugnant to the provisions of earlier law made by parliament or an existing law with respect to that matter, then the law so made by legislature of state shall, if it has been reserved for the consideration of president and has received the assent prevail in that state, my lord. So Mr. Reddy was placing this 254(2), my lord. So for the 254(2) also envisages the reservation of bill to the President, my lord, and also under Article 288(2), my lord. The exemption from taxation by a state in respect of water or electricity, my lord, and the legislature of a state may by law impose, and then Article 288 also envisages reservation of the bill by the Honorable Governor to the President, my lord. And last article, my lord, is Article 360, sub-article 4(a)(2), my lord. Yes, my lord. Article 364, sub-article 4, notwithstanding anything in Constitution. Now, in the context of any such direction, it regard to, and the bill can be reserved for consideration. A small Roman 2, a provision requiring all money bills or other bills to which the provision of Article 27 apply to be reserved for consideration of President. So in all these matters, my lord, so there is no time limit, my lord. And as the expression in Article 201 does not contain as soon as possible, my lord.
Yes.
So my submission is, my lord, that the matters which fall exclusively in the domain of the President, my lord, no timeline has been set in Article 201. But the matters where,
So according to you, insofar as governor is concerned, the timeline is there.
yes,
Insofar as president is concerned, there is no timeline.
in respect of these matters, my lord, the items which are covered under the Constitution, my lord, the inaction may not be there, my lord. Inaction in deciding one way, because judicial, the constitutional inaction is also a kind, there will be some decision on those aspects, my lord, but there is no timeline, strict timeline. Because, my lord, if I was going through the Hindi part of the Hindi version of the Constitution, my lord, and in Hindi version of the Constitution, what I found, my lord, the expression used for as soon is yatha sigra. Yatha sigra, my lord, is, if correctly translated, my lord, it forthwith.
Yeah, what did you say? Yatha
Yatha
sigra.
sigra.
Yatha
Yatha sigra.
Yatha shigra.
Shigra matlab jaldi, yatha.
Yatha sigra. If I, so, my lord, the Hindi,
As soon as possible.
as soon as possible, forthwith.
The stronger this thing, forthwith.
I think, my lord, nothing turns on it, but yatha shigra possibly is as soon as possible. Forthwith, I'll just find out the Hindi word for forthwith, my lord.
So
Turant, my lord, my learned friend is saying. That's Hindustani. But subject to, my lord, correct.
तुरंत प्रभाव से.
Pardon, what?
Official language, normally the word used is तुरंत प्रभाव से.
Turant, yes, tatkal prabhav se, yes.
So,
With immediate effect. The kal prabhav se, with immediate effect.
With immediate.
जितनी जल्दी हो सके, my lord, that the yatha sigra not is जितनी जल्दी हो सके. As soon as is जितनी जल्दी हो सके, my lord. And yatha sigra, in my humble submission, is forthwith. So if I can please, my lord, unfortunately, it is not part of my written submission.
The Constitutional Assembly debates are in English, so while interpreting the words, we'll have to go by
My lord,
the text in the English.
yes, my lord, but this is also a tool to interpret, my lord. This is also an aid to interpret.
Translation, which is the judgment shows that the translated version is a judgment of interpretation.
Yeah,
Shows a judgment.
yes, my lord.
Any judgment which says that the translated version of a statutory provision is an external aid for interpreting that provision.
No, the point which I was trying
No,
to.
you are saying that it's an aid for interpretation, so
No, my lord.
first one judgment will.
No, my lord, in larger context, my lord, in larger context, my lord.
Hindi version is an aid to interpretation. Yes.
We are also saying as soon as baby is forthwith.
Yes,
We are
forthwith.
also- That's the right principle.
Official version of Constitutional translation.
Soon as possible.
Then we are aid to interpretation. Yes, Mr. Amit.
Yes, my lord. Now, my lord,
You give a written notes, we'll come.
yes, my lord, one more point, my lord. 145.3, my lord. Kindly see my written argument, my lord, on 145.3, my lord, because that at page 336 of my written argument, my lord. No, on this-
So far he's on the right side.
Huh?
I said so far he's on the right side.
Written notes, at what page?
Yes, page 337, my lord.
Because having volume 2 point.
Volume 2. Volume 2. Volume 2. Volume 2. Your lordship will now under there, my lord, according to my lord, paragraph 80, my lord, the honorable, when hearing an appeal is obliged to refer any question involving a substantial question of law as to the interpretation of constitution to larger bench, provided two conditions are satisfied. First, this honorable court must be satisfied that the issue in question indeed raises a substantial question of constitutional interpretation. Second, it must be satisfied that the resolution of that question is essential for disposal of the appeal. Once both limbs of this test are met, the proviso use of the term shall render the referral mandatory.
This is with regard to maintainability.
Yeah, with regard to the reference of that 140, whether it is 145.3, it is to be referred to 5 judges bench when the question.
The
In-
argument is not considered by the.
Yes.
Yes, it is in the context of, my lord, whether.
What is your proposition? You tell
My
us.
proposition is when the issue relating to interpretation of the constitution arises, my lord, it should be referred to the larger bench. It should be referred to 5 judges bench, but only on.
For that argument, you have to be on this side.
You know, on this, because that is, I am in middle, my lord.
You are neither here nor there.
And on middle, my lord, because I borrow the words of learned solicitor. It is not adversarial, because learned solicitor started the entire discourse with this submission that it is not adversarial. And here we are assisting your lordship to come to the right conclusion, my lord. And so I have cited 2 judgments on this, my lord. Kindly see, and the Supreme Court rules also, paragraph 82, where Supreme Court rules are there, my lord.
Order 622.
Yes, paragraph 82 at page 338, where during the hearing of any cause, appeal or proceeding, a bench considers that matter should be dealt with by a larger bench, it shall refer the matter to the Chief Justice, who shall thereupon constitute such a bench for hearing of. The repeated use of term shall in both the rules and enabling provision imparts mandatory force to the referral process, leaving no room for.
Anyway, we are not going to into that question whether the division bench ought to refer it to a larger bench or not. That's not an.
So, my lord,
question
your lordship has considered this aspect in 2 judgments, my lord.
We are not considering that question as we are not on the correctness or otherwise of the judgment of the division bench as to whether they were not justified in referring it to a larger bench or not.
Because, my lord,
We are only answering the reference.
my lord, so
Yes, thank you, Mr. Amit.
I'll place, my lord, my written arguments on this.
Yes, Mr. Wilson,
Yes,
10 minutes each.
yes. Grateful to your lordship, my lord. My lord, petitioner always, my lord, thinks of, my lord, participation in these types of matters. My lord, in order to assert, my lord, the state's autonomy and federalism. My lord, I'm grateful to the learned Solicitor General, my lord.
Even otherwise, we are going to forgive.
Yes.
You
Grateful
will
to
be grateful to you.
Yes, grateful.
Then if
to
you are going to
Yes,
meet others,
yes, my lord.
at least because
Yes.
of the live streaming, then
Lord, I have filed my written submissions.
yes.
Lord, I have divided into 2 parts. Lord, page number 1 to 11, my lord, is a key to my written submissions. Volume 2.14. 14. Lord, this article, Lord, we have been wandering in this court for a longer period. Lord, we have brought this special reference. And my lord, we know the pain which we have undergone, Lord, in approaching the courts and ultimately, my lord, getting an order in our favor. Lord, that is why, my lord.
We are not going into
Yes.
the correctness
Yes.
or otherwise of the judgment
Certainly,
of the
my lord.
division.
Certainly, my lord,
We are only
I do.
restricting ourselves to the
Yes,
question.
I bow my head, my lord. I am grateful to your lordship, my lord.
So don't
Yes,
Personalize it.
Don't
yes.
bring your pen before this court.
Lord, whatever may be, Lord, today the states are celebrating this judgment. That's what I wanted to place it.
This is again,
Lord, yes. Now, my
You
Lord,
are-
see the legislative procedure. Yes,
When you argue a matter, it is expected that you
yes.
argue a matter with some sort of detachment.
Lord. Yes, certainly, my Lord, certainly. My Lord, I have to just place, my Lord, what has made us, my Lord, to come before this court. Now, my Lord, legislative procedure, this article 200 and 201, my Lord, falls, my Lord, under the heading of legislative procedure. Lord, this legislative procedure, my Lord, should be understood in the context of the Constitutional Assembly debates, rule of law, and, my Lord, the principles and approaches adopted by the constitutional courts. My Lord, therefore, this legislative process, my Lord, which your Lordship is going to interpret, my Lord, your Lordship has to take into consideration that the people's, my Lord, elect a government, my Lord, or a representatives, my Lord, with a fond hope that they will give good governance within 5 years. Therefore, my Lord, the legislative process should be fair, reasonable, uphold legislative supremacy, respect states' autonomy, support the federal structure, and promote parliamentary democracy. My Lord, that is what, my Lord, this 200, my Lord, altogether, my Lord, your Lordship has to look into it. So therefore, my Lord, if your Lordship sees how, my Lord, Article 21, when the word, my Lord, procedure, my Lord, is there in Article 21 is interpreted by this court in Maneka Gandhi. My Lord, I have stated that, my Lord, in B. My Lord, if your Lordship sees, I have enclosed that, my Lord, in page number 11, internal page number 11, 1506. Lord, Maneka Gandhi's case, my Lord, clearly says, Lord, at page number 1507, that the procedure should be fair, transparent, and, my Lord, addressing the functions of the governor, time limits and methods of handling bills, including reserving them for the President's consideration and setting time limits for the President's action in terms of constitutional scheme falls well within the jurisdiction of this constitutional court and judicial manageable standards envisaged in the Constitution. The Honorable Court is tasked with the ensuring that both the procedural and substantive validity of any legislation align with the constitutional provisions. This includes interpreting the relevant procedures clearly and ensuring the effective functioning of constitutional institutions, not constitutional institutions including governor. This in turn enables the upholding of rule of law, delivering good governance. That's very important. For a people, we go before the people, we get elected, we come, Lord, and form the government, and Lord, we have to, Lord, give good governance. Lord, that is very important, and within 5 years, Lord, we have to do it. And therefore, Lord, there's a meaningful participation by the representatives of the people. These elements are essential for maintaining parliamentary democracy. Therefore, this Honorable Court is well within the time limits to interpret the legislative procedures embodied in Article 200 and 201 as exercised by the Governor and the Honorable President. Then, Lord, I have also said, Lord, at C, paragraph C, Lord, in my key to the written submissions, Lord, page 1497, a judgment of this court, Lord, in Roger Matthew versus South Indian Bank Limited. Lord, if your Lordship sees, Lord, page 12, I have extracted that judgment. Kindly see, Lord, page 12, 1507, para 11. Lord, in Roger Matthew, whether, my Lord, the court can go into the legislative, test the legislative procedure. Lord, this court said, Lord, paragraph 11, I have extracted. Since the Constitution explicitly provides a self-contained detailed procedure for enactment of legislation and does not suggest that mere assent of the President to a law by whatsoever method adopted would become a valid law, it is necessary that this court, being the highest constitutional forum for judicial review, is provided with enough space for enforcement and protection of the constitutional scheme. Thus, a mere presidential assent does not validate a law by any method. The Honorable Supreme Court, being the highest constitutional forum for judicial review, must be provided with enough space for enforcement and protection of the constitutional scheme. Then, my Lord, I have also, my Lord, quoted Kaiser Hind, my Lord, 2002, 8 SEC, page 182.
Roger Matthew is with regard to the power of this court to examine whether the law violates any of the provision of the Constitution or not.
Not, my Lord, including the procedure, my Lord, which is set out in the Constitution. my lord, because the procedure, my lord, 200 and 201 comes, my lord, under the heading procedure, legislative procedure. My lord, my humble submission would be, my lord, this court is empowered, my lord, to see whether the procedure which your lordship is going to, my lord, interpret as per the constitutional debate, my lord, is fair and reasonable, so that, my lord, it takes into consideration all aspects. Then, my lord, this Kaiser Hind also, my lord, if your lordship sees page number 11, my lord, paragraph 12, my lord, I have extracted this Kaiser Hind. My lord, that relevant paragraph, my lord, at page number 12, at paragraph 12, my lord, para 29, my lord, it says, we further make it clear that granting of assent under Article 254(2) is not exercise of legislative power of the President, such as contemplated under 123, but is part of the legislative procedure. Whether procedure prescribed by the Constitution before enacting the law is followed or not can always be looked into by this court. Therefore, my lord, the granting of assent is not exercise of legislative power, such as contemplated under the Constitution, but it's a part of legislative procedure. And my lord held that the procedure prescribed by the Constitution before enacting the law is followed or not, my lord, court can always look into that. Then, my lord, with regard to the immunity, my lord, at page number 1497, my lord, my lord, I have said about the Rameshwar Prasad 2006 2 SEC, page 1, my lord, where immunity available to the governor does not take away the power of the court to examine the validity. Then, my lord, I have also extracted S.R. Bomey's case 1994 3 SEC, page 1, where, my lord, judicial review is a basic feature of the Constitution. The arm of the court is long enough to reach injustice, and actions of every highest constitutional functionary is subject to judicial review. And if your lordship sees, my lord, state of Rajasthan, my lord, that I have extracted, my lord, at page number 14. If your lordship sees, my lord, page number 1509, para 15, the state of Rajasthan is very important, my lord. Para 149 particularly, it says, this honorable court held that whenever a question arises as to whether a constitutional authority has acted within or exceeded its powers, it is a constitutional duty of the court to decide it. The Constitution is the supreme law of the land, binding on every organ of the government, executive, legislature, and judiciary alike. No authority, however high, can be the sole judge of the extent of its power under the Constitution. This court, as the ultimate interpreter, is entrusted with the task of defining the limits of power, ensuring that no branch transgresses them, and upholding the rule of law by enforcing constitutional limitations. Then, my lord, I have also extracted this Roger Matthew. Again, my lord, with regard to the interpretation of Article 212, my lord, to what extent, my lord, the court can go into the legislative procedure. My lord, if it is illegality, then, my lord, the court said, we will go into that. I have extracted, my lord, in page number 14. And so far as the judicial review is concerned, my lord, I have extracted, my lord, the judgments of this court, my lord, in fact, my lord, from paragraph 17, my lord, at page number 15, my lord, I have made a tabulations, my lord, S.R. Bomey's case, BP Singles case, paragraph 17, if your lordship sees, my lord, S.R. Bomey's case, BP Singles case, Kalpana Mehta's case, Rajaram Pal, State of Rajasthan, A.K. Kaul, Kaiser Hind. My lord, in all areas, my lord, there the judiciary, my lord, has interpreted, and that's how, my lord, the institutions are functioning. My lord, this is an area where, my lord, till, my lord, this Tamil Nadu state was Tamil Nadu governor fixing the deadlines. My lord, it was an area, my lord, where it was subject to interpretation. Now, my lord, that area is also settled. Now, if your lordship comes to, my lord, the questions, my lord, that is posed, my lord, by the honorable president, my lord, so far as question number 1 and 2, my lord, please come to page 3, my lord, of my keynotes. My lord, extent of power given to the governor. My lord, we are here, my lord, quoting Dr. B.R. Ambedkar's, my lord, speech. My lord, if your lordship comes to page number 18, my lord, I have quoted B.R. Ambedkar's speech, my lord. Where, my lord, he says, my lord, at page number 18, para 20, but where he says, yes, my lord, kindly come to 21, my lord. My lord, this is what, my lord, we expect. Lord, in fact, an assurance is given by Lord Dr. B.R. Ambedkar, Lord, when all states were coming together. The drafting committee felt, as everybody in this house knows, that governor is not to have any kind of functions. To use a familiar phraseology. Yes. Lord, this word was not read, that's why.
Already
Read, my Lord, then I'll skip it, bro. Grateful to your Lordship, my Lord. Then, my Lord, your Lordship, kindly come to, but how this article, my Lord, 175 and my Lord, 91 was made, my Lord, much argument is made. My Lord, I'm skipping that, my Lord. And, my Lord, my submission would be only that, my Lord, there are only three, my Lord, ways, my Lord, where it was argued much, my Lord. And, my Lord, always the governor has to act under the aid and advice of the Council of Ministers. Now, my Lord, with regard to the false through, my Lord, much argument was made on the basis of, my Lord, Alluri Basavia Chowdhury. My Lord, our submissions would be, my Lord, the will falls through means bill dies where it is born. My Lord, governor cannot withhold, my Lord, bill on his own and bury it at Rajbhavan. My Lord, as explained in the Constituent Assembly debates, it can be only exercised under the aid and advice of the Council of Ministers. And, my Lord, why it is, my Lord, sent back, withhold is, my Lord, to remedy a hasty action or when the ministry or the government changes before the bill is assented by the governor and a new ministry is
That is
formed.
already argued.
Yes, that is argued. My Lord, in fact, Samshir Singh, Nabam Rabia, my Lord, Kaiser Hind says, my Lord, at page number 35, kindly see, my Lord, page number 35. My Lord, this is a page number 35. Lord, they say, Lord, bill is nothing but expression of political will. Apparently, the will of the people expressed through the legislation passed by the elected representatives. To that extent, my Lord, I'm quoting this. And, my Lord, the governor, my Lord, he can't be a constitutional court, my Lord, that we have, many of them have argued. Now, my Lord, your Lord should kindly see one of the important submission is, my Lord, this federalism, Lord, ingrained into the constitution. Lord, what Dr. Ambedkar said, if your Lordship comes to, Lord, page 37, Lord, I have extracted, Lord, Dr. Ambedkar. Our fear is, Lord, whether the federalism or a state autonomy is going to be lost. Lord, in the exercise of, Lord, interpretation of Article 200. Kindly see, Lord, paragraph 40, what Ambedkar said. Lord, this is on 26th November 1949.
25.
There is only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities. It is clear that this view is not only an exaggeration.
Already, we have read it so many times.
This is not read, my Lord.
It is read.
Yes, my Lord. Then I skip that, my Lord. Then your Lord should kindly, yes. Then your Lord should kindly see, my Lord, the time taken by the bill.
Where Dr. Ambedkar says that insofar as states are concerned, they have an exclusive right to legislate on them.
Partition, the power is partition between the state and the
Insofar as
center.
Parliament is concerned. So this has been read so many times now.
Yes, and Lord, how the constitution has to work.
You had your 10 minutes
Yes,
now.
Lord, I will finish it off, Lord. But if your Lordship sees, Lord, the constitutional silence, Lord, courts have interpreted, Lord. Yes.
Mr. Wilson, the only new thing which, of course, no one has referred to is your diagram at 1527. So better you rely on that.
Grateful to your Lordship, Lord.
Colorful also. Colorful.
A colorful diagram, Lord. Yes, Lord. Lord, I will just skip, Lord, certain points. I'll summarize. Lord, I have said about the constitutional silence, Lord, which your Lordship can interpret, Lord. This has been said in Krishna Kumar Singh, Jai Shri Ram Patel, Kesavananda Bharati, and K.S. Puttuswamy, my Lord. This court has said, constitutional silence is a dark matter like dark matters in physics. These elements are not directly observable in the text, but without them, the constitution would collapse in incoherence. Lord, that paragraph, my Lord, I have marked, my Lord, page 46. Then, my Lord, I have extracted, my Lord, the judgments, my Lord, where they said about the constitutional silence. And, my Lord, because of this Article 356 interpretation in S.R. Bomai's case, today, my Lord, we are saved, my Lord, from indiscriminate dismissal of the, my Lord, by the governors. And, my Lord, if your Lordship sees, my Lord, this as soon as possible, my Lord, the interpretation, what H.V. Kamath feared, my Lord, that is a fear coming to us, my Lord. That is a fear, my Lord, that I've, my Lord, stated in page 53, my Lord, paragraph 56. My Lord, what will happen, my Lord, if the timeline is not fixed? then, my lord, I will be, my lord, wandering in courts. I have given a schematic diagram also, my lord. My lord, therefore, my lord, the court cannot be a mute spectators, my lord, and I cannot, my lord, court cannot be one of the layer between the governor and the act coming into force. Every time, my lord, I cannot come, my lord, I filed a writ petition in 2023. I'm giving one example. My lord, and 2025 only, my lord, the judgment was delivered. Nearly 2 years, my lord, I was wandering in the courts. Therefore, my lord, my humble submission would be, my lord, this timeline also, if your lordship sees, there is already a memorandum, my lord, which we have enclosed. Your lordship would kindly see, my lord, that memorandum at page number, Lord, 1551. This memorandum is extracted, my lord, in the judgment of Tamil Nadu government versus Tamil Nadu governor's case. This memorandum, my lord, passed by the central government, clearly says has got the approval of the cabinet, which says 3 months, my lord, the bill has to be disposed of. My lord, I have, my lord, enclosed at page number 1551. My lord, when the government itself, my lord, have decided to decide, my lord, all the bills within 3 months, and cabinet has approved. My lord, when cabinet has approved, my lord, it has got a flavor of Article 73. My lord, it becomes a law. My lord, what is difficulty now, my lord, in court saying that, my lord, within 3 months the bills have to be disposed? Therefore, my lord, they will not have any difficulty, my lord, in dealing with this because they already have a mechanism like this, but they are not doing it. Page number 1551, my lord, I have extracted that. So therefore, my lord, my humble submission would be that the advisory jurisdiction, my lord,
Yes, yes. Mr.
advisory, my lord, I am concluding.
Yes, you are
Concluding, my lord. Advisory jurisdiction, my lord. Only when, my lord, there is a law that arises for consideration, my lord, the president can refer it under 143(1). But here, my lord, there are list of laws, my lord, I have enclosed list at page number 70. Kindly see, my lord, page number 70. All questions, page number 70. My lord, I have given a tabulation. My lord, Tamil Nadu government versus Tamil Nadu governor is a complete answer for all, including, my lord, other cases. I have given all, my lord, the judgments, my lord, the questions raised in, my lord,
Thank you,
by
thank
the
you, Mr.
president.
Thank you.
And, my lord, lastly, my lord.
Thank you, thank you.
Yes. Yes. And, my lord, this, so far as 91, my lord, when it was, my lord, debated, they say that similar, my lord, be applied to 175. My lord, why they say is, my lord, your lordship would kindly see these timelines. If the bill returned by the president, my lord, this is there at volume 28. My lord, this alone, your lordship may note it, my lord. My lord, why the timelines, my lord, was skipped, my lord, when Article 91 had 6 weeks, is, my lord, they wanted, my lord, the bill as soon as it comes back. Yes. My lord, therefore, my lord, my humble submission would be, my lord.
We are granted to 10
Yes,
minutes.
my lord, this judgment, my lord, that is in place, my lord, is really helping the states, my lord.
We are not concerned with the judgment. How many times we are telling
Grateful
you?
to you. All the judgments, my lord, I'm only referring to all.
How many times we are telling you?
Grateful to you.
Don't get so much personally.
Grateful to you, lord.
May it please, Lords. Lords, if your lordships could kindly have volume 2.13, that's 1.3. In the soft copy, maybe better if your lordships can access that, because when you tap on it, it'll take you to the appendix, which has references on the soft copy, but otherwise the hard copy is fine now. There are a few points I have to make which have not been made so far. I'm not doing anything which has already been addressed. Can this be just handed up to you?
You are appearing for who?
There are two applications in which I'm appearing, which 176467 and 175970. One is an advocate, the other is a former DGP of police. Both citizens, both wish to address your lordships on this. Yeah, I'm just handing up copies of this constitution, my lords, which has the previous provisions in the footnotes, which may be relevant.
You already have your.
I do it customarily before constitution.
Every constitution bench.
This is the latest.
How many copies we should keep?
I have done that. It's a latest edition. So if your lordship will just.
I can replace it with.
Yes.
Well,
In fact,
if we look
this
at the first
particular
page,
edition,
if
this
you look at the
particular
first
edition,
page,
if
well,
you look
it's-
at
it's
the
a very
left
good-
side, the first page, you'll see the quote of Justice Vivian Bose from BD Supply. It is
Lord,
very,
if
very
your
important.
lordship sees the first page, well, it's an amazing effort by him, my lord, no doubt about it. But a layman would understand that rather than Dr. Ambedkar, Mr. Gopal Shankar Narayan has written this constitution.
Or Mr. Rahul Gandhi. So, the lordships can just.
Yes.
Now, my lords, in the constitution, just to start, just see Article 145, subclause 4 for a minute. 145.4. This has not been read to your lordships yet.
145.
145, subclause 4.
No judgment shall be delivered.
Yes, if I can read that. No judgment, the word used is judgment, shall be delivered by the Supreme Court save an open court. Lord Sir, my Lord the Chief Justice. And no report. Please note the word report. This is very critical to this entire exercise. And no report shall be made under Article 143, save in accordance with an opinion also delivered in open court. So the Constitution envisages from day one that what your lordships are doing now is not a judgment. It is a report based on opinion. Now, because it says no judgment shall be delivered, save in open court, and no report shall be made as far as 143 is concerned. So the advisory opinion is a report, merely a report. What flows from that is a little critical for the purposes of your answering those 14 questions. So this is in fact a recognition of what took place before the Constitution came into effect. The Constitution took Section 213 of the Government of India Act. It effectively copy-pasted Section 213 into Article 143. The only addition were on questions of fact. Questions of fact were not considered by the federal court in its advisory jurisdiction earlier. So what your lordships are doing now is a completely different jurisdiction from the jurisdiction your lordships embark on in 32, 131, appeals, 136, etc. It's a completely different jurisdiction. In that jurisdiction, your lordships are being asked by citizen number 1 for guidance. Now, the way under Section 213 of the Government of India Act, this was referred to is relevant, and I'll tell your lordships the reason why it's relevant. That if for a minute your lordships will see Article 374 of the Constitution.
Article
374. Subclause 2 of Article 374. All suits, appeals, and proceedings, civil or criminal, pending in the federal court at the commencement of the Constitution shall stand removed to the Supreme Court, and the Supreme Court shall have jurisdiction to hear and determine the same. And please note this, the judgments and orders of the federal court delivered or made before the commencement of this Constitution shall have the same force and effect as if they had been delivered or made by the Supreme Court. So, all those that were delivered by the federal court are effectively binding on this court by virtue of 374(2). The reason I mentioned this, and this is why I don't want to duplicate what has been said before, but I'm just flagging it. Mr. Datar yesterday mentioned the estate duties case, which was one of the 4 references under Section 213 heard before the Constitution came into effect under the Government of India Act. The estate duties case is very critical about what they say about advisory jurisdiction. There are effectively 3 judgments of your lordships which have dealt with what the advisory jurisdiction is and what the chapeau of that is. And the first one is the estate duties case then. The second one, so far you've had 15 references under 143 before this court. The very first one, Delhi laws, did not deal with the issue. But the second one did, which is Kerala Education Bill. So there are many passages of Kerala Education Bill which look at estate duties, look at what the scope is. That same aspect of what the scope of 143, Article 143 is then considered by your lordships in the majority in Ahmedabad St. Xavier's, 9 judges. Noted, in fact, in the majority of Privy Council, Privy Purses, which is 11 judges. Noted finally by Chief Justice Chandurkar, and this has been referred to in the special courts, both Mr. Reddy and Mr. Datar have referred to. What they say across this swath is as follows, and if I can just show your lordship that starting point, that's all I want to show your lordship from this. Just see page 1369 of this compilation, page 1369. And if your lordships are looking at the soft copy, your lordships may click on Appendix 1. Just tap on Appendix 1, it will take you to 1369.
1369 of?
of this same volume, my lords, my compilation. I put everything here.
Yeah, go ahead. 2.2.
1369. This is Chief Justice Spence of the Federal Court, my lords. My lord, the Chief Justice has it, 1369. 19th
Yes.
page of the volume, yes. 1369. I'm reading from the bold portion, just the bold portion. It may be stated at the outset that when Parliament has thought fit to enact Section 213 of the Constitution Act, it is not in our judgment for the court to insist on the inexpediency, according to a certain school of thought, of the advisory jurisdiction. Nor does it assist to say that the opinions expressed by the court on the questions referred will have no more effect than the opinions of the law officers. This is Attorney General for Ontario versus Attorney General for Canada. That is the necessary result of the jurisdiction being advisory. So the role that is being discharged by the Constitutional Court in its advisory jurisdiction is effectively not more than that of what a law officer would do as far as government. Consequences follow from this. Now, if your lordships were to scroll down to page,
Yeah, we will be only answering the questions
very well.
as to what is it defects or not. That's not for us to decide.
Correct. So now I'm just in
Whether,
the,
whether it has a binding force
correct.
or it is only an opinion of a
That's
law
That's
officer.
already been decided. That's already been
So
decided.
as and when the question arises,
Somebody will
No,
decide.
the
It's
question,
not,
the
your
question
lordships
has
are,
arisen.
Lord, I have a serious objection to this. Your lordships are not making a report to the president. Please read the language. Report containing your lordship's opinion. Your lordships never report to anyone.
No, I'm
The
not saying
honorable
report to-
president, which my learned friend referred to
I don't
as
think he
first
understands.
citizen,
It's a
is,
con-
you meet that in your region.
yes, my lord, but
You reserve that for
you have
region.
to be respectful to the president.
Again, we'll have to.
I don't need instruction
Yes,
from you about
Lord.
being respectful, please.
Yes.
Yes, no,
I don't
nobody
think these
can.
Unnecessary interruptions are
Nobody
necessary.
can.
It constantly keeps happening from the Solicitor General. Now, if you see that first page of my note, which is at page 1354, my lords, page 1354.
This point you can skip, Mr. Shankar Narayan.
I just want, there's a sequitur to this point. There's a sequitur. First, this has been decided fully. It's been decided not in a list. In Ahmedabad, St. Xavier's, it's been decided. In Privy Purses, it's been decided. So that question whether it's binding or not has been decided by 11 judges saying,
So we are not going to decide that.
no, I'll tell you the
We are
reason.
answering the questions that are.
No, so the
Whatever worth it is, that will be tested somewhere else.
sequitur to this, I'll explain what the sequitur is. The sequitur, as a result of this, what is
You may argue this in a subsequent matter where this is
No, I-
considered whether what is the.
No, your lordships are fair. So just ignore that first page, come to the second page, 1355. Just come to the second page. The reason is that rather than revisiting everything, going into 200, etc., your lordship's role in this is much less than that. That's what I just want to emphasize. Just see 1355 for a minute. These are the consequences. The essential aspects of Article 143 jurisdiction are, this is 1.8 that I'm reading. First, it's an opinion in the form of a report. Second, no list is decided, no dispute is adjudicated. As a result of this, my lords, provisions 141, 142, and 144 of the Constitution do not apply to advisory opinion. If it doesn't, the consequences are at the bottom of the page. What the court's approach perhaps could be in this particular case are as follows. First, that if you see that none of the 15 judgments of your lordships previously have referred to 145.4. None of them. None of the 15 judgments have overruled a previous judgment. None of these 15 opinions have been overruled subsequently. The consequence of that is that when 14 questions are put to your lordships, of which 10 questions, between 9 and 10 questions, are answered by a judgment of this court, the opinion that anybody would give when that question is put is effectively that these questions are answered in these paragraphs of this judgment and end the matter there, not reopen that further. In
That
fairness,
has already been argued.
correct. So
You said that
there
you are
are,
going to argue something new.
yes, so the something new will be with reference to those
Already,
questions which are
No,
recent.
you have already crossed your 10 minutes.
Very well, Manoj. If I won't take long. I'm just showing your lordships a few more facts. Come to the bottom of page 1356, please. 1356. Please note that this is not a recent issue. I told your lordships I'm taking a middle path. I want your lordships to know that this is an issue regarding reserving for
It doesn't
consideration.
appear to be that you are taking a middle path. On the contrary, you are taking a path which is more extreme than that is being taken by the
No.
I think with the states on this side.
No, the states on this side, I think, are all ad item on one fact. And I'm very surprised, Malad, that states should at all be on that side at all. Coming and saying, we'll pass a bill, but we want our governor to sit on it. That's a very strange position, in my view, for us.
It is for them to decide it.
Yes, it is.
They have not sought your advice.
Which is why, exactly. They have indirectly, Malad, unfortunately.
They have not sought your advice as to what they should do.
Unfortunately for us, Manoj, we can only make our case here. We can't make it directly to the querist. The querist has lawyers. It's being made here. That's why. Manoj, the two submissions I'm making at the bottom of page 1356 are simply this. That if your lordship will just see that chapter, I'm not at leisure, please see that chapter. I've annexed it of Granville Austin. He details in para and verse how Chief Minister Morarji Desai in 1952 faced these problems, how from then on, state after state has been sitting on bills and there should be a solution. My submission is that solution has come. This judgment in the state of Tamil Nadu is that solution. It ensures that it's taken care of. In response to an argument that was made by Mr. Salve, that in the federal scheme, according to Mr. Salve, it is such that even if a state passes a bill, the central government via the governor can in fact prevent that bill from being passed. That was an argument that was made. That is answered in Hargovind Pant in that paragraph at the top of page 1357, which makes it very clear that the governor is not subordinate or subservient to Government of India. He is not amenable to directions of the Government of India, nor is he accountable to them. It's a constitution bench which has said this. So there is no question of that argument being countenanced in the least. My lords, your lordships have gone through the Shamsher Singh judgment, etc. On the interpretation of 200, there are three things which your lordship may please note. Just if you can see 200, three aspects which have not been shown to your lordship. So please see that. I acknowledge Mr. Vivek's
200
assistance to me. Vivek said he couldn't make these submissions himself, so he's assisted me in this. Article 200. So please note three things.
He was heavily assisting, you're standing next to.
No, my lord, he actually in the sequence he should have argued, but because I think the time is short.
No, because we have very the rule that only one.
No, I know. So eventually, my lords, because it's one client, the lawyer can't make that argument. So he's given me the argument to make. So if I just see Article 200, just please note at the end of that first clause, my lords, it says there's two things to be noted. One, it ends with a colon. That's very, very important. Right, my lords? Before the first proviso. At the end of that first proviso, there is one more colon. Now, in the indoor, I'm sorry.
So there's comma.
I'm sorry.
There's not a colon.
No, at the end of the next, first, end of the
So you are
main
saying-
provision, there's a colon.
Yes.
At the end of the first proviso, there's a colon.
Yes.
Yes, main provision colon, first proviso colon. Exact same scenario where after a colon, a proviso came up for discussion in that famous section 24(2) interpretation, my lords. Justice Arun Mishra's bench, heading Constitution bench on indoor municipality, your lordships will remember. The question was, does that second proviso, does it attach itself to the proviso just above it, or does it go to 24(1)? The answer given, we have annexed that also. Answer given was it attaches itself to what immediately precedes it. So if you were to interpret 200 in that sense, let me just give your lordship what I believe the answer is. I've put a chart which shows how that sequence flows. And let me just explain it for half a minute. There are 5 provisions, all of which were referred to by Mr. Amit Kumar, the Advocate General, who just spoke before me. 5 provisions in which there will be reservation for the consideration of the President. Only 5. Just to answer Justice Narasimha's question about the distinction between the use of the word act or law. in 254(2) versus bill which is used in 200. That is answered in Kameshwar Singh in majority, and it's followed in Valluri once again, saying that it makes no difference whether it's bill or act which is used, because the word used in 200 is bill. In those other 4 provisions, the word used is law. But they say it makes no difference. Therefore, there are 5 specific provisions, including the second proviso, where bills or acts are reserved for the consideration of the president. Barring those 5, the interpretation of 200 is clear. Every single bill gets assent. Every single bill gets assent. The question is when. Either you get assent immediately, or you withhold it for it to go back to the legislature. And once it comes back, you can't withhold assent. There is no other option. You have to give assent. That's the answer. In my view, there is no doubt about it, because that is exactly how it flows. So if your lordships note the flow of Article 111 with reference to the president and read it with this, 111 has only 2 options. It's assent or withhold. Here, if you consider the fact that there is money bill, if you consider the fact that there is reservation for the president, and the fact that if you see the words once again, which have been used after the presentation, if I can just read that first proviso, provided that the governor may, as soon as possible, after the presentation to him of the bill for assent, which means if you see the first proviso, it is clear that it is for assent. The words
That
are,
is what Mr. Amit Kumar also argued, that he said that we have to read the marginal note.
Yes.
no, I'm not on the marginal note. I'm on the first proviso.
So
It
according
says,
to-
provided that the governor may, as soon as possible, after the presentation to him of the bill for assent. It's not for any other purpose. It's only for
That's
assent.
what Mr. Amit Kumar also argued.
Very well.
We have already taken 20 minutes.
But I have 3 more,
No, we have,
3
we
more
have to,
submissions. Because,
we have to give time at least 10 minutes each to 3 others.
may I just make one submission?
We
Your
conclude it.
lordships have heard, your lordships have.
No, no,
heard
we have,
the
as an
submission.
intervener, we have sufficiently heard you. Yes.
No, I know, but I'll just take 2 moments. I'll just take 2 moments. Now, I'm skipping the justiciability part of it, but I've mentioned, if your lordship will just take the note, then I'll finish in 2 minutes. Just see 5.4, middle of the page, point 5.4. It gives your lordships the reasons
page?
why, page 1359, 1359.
Yes.
1359, 5.4. If your lordship sees, I've given 5 instances in the constitution where if the governor refuses to swear in a chief minister, president withholds issuing a warrant of appointment of a judge, governor does not lay annual financial statement. All these instances, your lordships will step in, because the question always being put is, these are not instances in which you will step in. There are multiple instances which can occur. Thankfully, they've not occurred, but multiple instances where it will be demanded that there will have to be a neutral authority who steps in and plugs that issue. That has happened in this particular case. We have given 2 full annexures, if your lordship will see page 1360. Appendix 8 and Appendix 9 are multiple instances, my lords, where your lordships have stepped in. 1360, if your lordship sees 6.1 and 6.2. Series of instances where, with reference to speaker's decisions, with reference to Article 161, etc., your lordship 324, appointment of the election commission, you have stepped in. On timelines, apart from the speaker judgment, the second judge's case, Scora, your lordships impose timelines on yourself. That has not been read to your lordship. Please read the concluding part of Scora. Timelines of 6 weeks, 4 weeks, 1 month, etc. are put on every authority there, which is president, governor, and Supreme Court. So the fact that timelines are being put on high authorities should not come as a surprise. It's happened repeatedly in the past. My lords, with reference to 145.3, just want to answer one question that Justice Narasimha had put yesterday. If you see 145.3, it is only dealing with this part, and it's dealing with appeals. 145.3, where it says refer it to 5 judges, is only dealing with this part. This part is chapter 4 of part 5. Right, my lords? chapter 4 of part 5 and the appeals therein, we have also put a chart which tells you the number of cases you have pending. But as far as the state of Tamil Nadu case is concerned, because that point was taken, saying that they had asked for a reference, there is no mandate in writ petitions, Article 32 writ petitions, for the framing of this question. Because that was an Article 32 writ petition. And there, because 145.3 doesn't apply to the 145.3 proviso, does not apply to Article 32. It doesn't fall in that part at all. That's one last point I wanted to make. Well, I think there's more to be said, but I hope my written submissions will be read. I don't want to take any more of your stuff. I'm great.
Yes, Ms. Bansal is before you.
Lordship, may I say?
She is before you in the list. Thanks.
Wait, please, my lords. My lords, considering that I'm the youngest arguing, my lords may just give me another 5 minutes and
No,
at
no,
least
10
allow me
minutes.
15 minutes.
There are three left. You, then Mr. Jain and Mr. Sajeva.
At least 15 minutes, my
No,
lords,
no.
that's all I'm requesting.
10 minutes each.
All right. In that case, my lords, in my allotted 10 minutes of time, I would like to restrict myself to only the question of timelines. My lords, a lot of other arguments and issues have been addressed, and I will, on the question of timelines, make only 3 arguments, which in my humble submission have not been made before. Now, my lords, before, if I had the time, I would take my lords to paragraph wise of my written submission. I've already circulated my written submissions, my lords may kindly take note of. Volume 2.9, my lords. Volume 2.9, page number 1197 onwards. Now, my lords, if I may just show you one annexure, which is important that we have put together, which is on volume 9, page number 1221 of my submissions. Page number 1221 of my submissions. My lords, it's a table where we have said and we have argued, my proposition is that there are actually 4 categories of timelines which are running through the Constitution. And the table, my lords, have it on page number 1221 of volume 2.9, annexure 1. Now, my lords may see that there are 4 categories in which the question of timeline has been divided in the Constitution. It's something which is like an undercurrent running through the entire constitutional scheme. My lords, the first category is where no timeline has been provided. And this court has read the requirement of reasonableness into it. My lords, for example, Article 161, mercy petition. We know that in Eji Parivalam case, it has been referred to before. No time period mentioned in the constitutional provision, yet the requirement of reasonableness has been read into it. Now, my lords, second example, for instance, paragraph 6th of the 10th schedule, my lords will see, again, in Kesham Megachandra, I know my lords are aware of the facts of the case, it has been referred to several times. No time period, my lords, in paragraph 6 of the 10th schedule, and yet my lords read the requirement of reasonable period. My lords, so this is the first category, and there are more, where no timeline absolutely or any word suggesting timelines, and yet the courts read into the requirement of reasonableness. Now, there's a second category where there are specific timelines mentioned in the Constitution itself. It's a long list, my lords, but for instance, Article 123 subclause 2, Article 213 subclause 2. For example, that the ordinance must be laid before the legislature and that it will cease to operate 6 weeks after reassembly unless approved. Now, my lords, there's a long list of my lords may have the table. Since this is a point which requires least consideration, I'm not going to focus on the second category. If there's a specific timeline, you ought to follow it. Now, there is a third category, my lord. And my focus is that there is an attempt, while we're discussing as soon as possible, not enough has been said, my lords, on as soon as maybe. And that is my first major argument today. that there is a third category called as soon as may be. And my lords, there are 17 times that in the constitution, the phrase as soon as may be has been referred. And then there is a fourth category right next to it, my lords, which says as soon as possible. Now, my lords, in the interest of time, I will just refer to one particular paragraph, which will bring out the difference between as soon as may be and as soon as possible. My lords may kindly have, my lords, my written submissions, so volume 2.9, page number 1203. Page number 1203.
Yeah.
My lords, I've also included it in the drive. So if my lords are looking at the drive, it's volume 5.58, page number 22641. My lords have it. My lords, volume 5.58. Page number 22641, or my lords may just look at my submissions, page number 1203. Yes.
From 1203.
Very well, very well. Now, my lords, this is a judgment, Ram Kishore Arora versus Director of Enforcement, 2023 INSC, page number 10821. And my lords, if I may quote paragraph 19 and 20 of this judgment, I quote, in view of the above, the interpretation of the expression as soon as may be assumes significance. In our opinion, the interpretation of the said expression should not detain us more in view of the Constitution Bench judgment in the case of Abdul Jabbar Bhatt and another versus State of Jammu Kashmir. In the said case, the Constitution Bench, it was a Constitution Bench, my lord, Abdul Jabbar Bhatt, while interpreting Section 8 of Jammu and Kashmir Preventive Detention Act 2011, had an occasion to interpret expression as soon as may be, and it observed thus. My lords, this is the key operational part. The observations of Justice Assent in King's Old Country Limited versus Liquid Carbonic Corporation Limited quoted Stroud's Judicial Dictionary and said, to do a thing as soon as possible, my lord, they are also distinguishing it. I mean, they're using both as soon as possible. As soon as possible means to do it within a reasonable time, with an understanding to do it within the shortest possible time. Likewise, to communicate the grounds as soon as may be, may well said to mean to do so within a reasonable time, with an understanding to do it within the shortest possible time. Now, when we read those two sentences, it looks like the same thing is being said, which is why we ought to read further. The words as soon as may be came for consideration before this court in Ujagar Singh versus State of Punjab. And at page number 76162, this court observed that the expression meant with a reasonable dispatch, and then went on to say that what was reasonable must depend on the facts of each case. My lords, may kindly just turn the page, and I have one last line. My lords, page number 1204 of my submissions. My lords, there a phrase is used which will give us the key of distinction between as soon as may be and as soon as possible. And I quote, my lords, it's highlighted on page number 1204, first paragraph. The words as soon as may be in the context must imply anxious care on the part of authority concerned to perform its duty in this respect as early as practicable without avoidable delay. So, my lords, my submission is that it is not by chance that the phrase as soon as may be has been used 17 times. And as one of the learned counsel submitted before me, the word as soon as possible has been submitted 7 times. And now my submission, my proposition, my lords, is all of these terms and categories cannot be just thrown into a reasonableness requirement which is amorphous and malleable. So in cases where there is no time requirement, my lords, say reasonable period, and rightfully so. But where there is as soon as may be, there is reasonable period. But then when there is as soon as possible, if my lords, we still rely on reasonable period, then what is the import of the words as soon as possible? So my lord, that brings me to my second argument, that my lords have a historic opportunity in my humble submission to lay down, at least at the bare minimum, that the words as soon as possible as a meta principle have a higher threshold than all the other timelines provided in the Indian Constitution. My lords, right now I'm less so on the specific timeline. I'm just going to come to it in 1 minute's time. But my major argument, my lord, is that this is an opportunity to remove this confusion and say, while reasonable requirement is underlying all these different categories of timelines, but as soon as possible, my lords, which is used 7 times in the Constitution, has to mean more than as soon as may be, and therefore has a higher threshold, and therefore a more expediency requirement as compared to as soon as may be. Now, my lord, that brings me to my second argument, that if my lords accept this argument, that as soon as possible is a higher threshold, that still begs the question that can this court, and I mean, we're looking at the Tamil Nadu judgment while this is advisory, but this question is before my lords, that can specific timelines be laid down? So can the court decide 1 month, 3 months, so on and so forth? And I also ask myself the additional question that what will be the ramifications of that when as soon as possible comes up in other places in the constitution? So for example, can this court then be laying down specific timelines in other places also where as soon as possible comes up? And to that, my lord, I have twofold submissions. My first submission vis-a-vis specific timelines is this, my lord, that my lords have ample power under Article 142 to do complete justice, and that is not a limited power to lay down timelines only in specific cases. My lords, it is true, and I acknowledge humbly that every time this court has laid down timelines so far has been specific to the facts of the case. But I am suggesting, my lord, that under Article 142, there is nothing to prevent my lords to also lay down systemic guidelines, except two things have to be seen. The first thing, my lords, when laying down systemic guidelines for time to come is, the first question is that whether this timeline is consistent with constitution provision and it's not violative of any other statutory provision, which in this case I'm suggesting that putting in the 1 month requirement, going back to my argument, because of a higher threshold of as soon as possible, is in no way substantially, is in no way going to change the nature of Article 200 and 201. And because of that, my lords, read with Article 142, it is my humble submissions that my lords, once they lay down that as soon as possible is a higher threshold, then Article 142 can permit them to lay down systemic guidelines for time to come, as long as my lords also hold that this 1 month, 3 months time period is not going to change the substantial nature of Article 200 and 201, which it is my submission that it does not. And the second argument, my lords, I mean, going back to IC Golaknath and another, we know that Article 142, it was held in IC Golaknath, has been used to evolve legal doctrines to meet the ends of justice. My lord, that primarily summarizes my first argument. As soon as possible is a higher threshold, distinct from as soon as maybe, cannot be thrown into an amorphous reasonable period. And second, read with 142, there can be systemic timelines. Now, my lord, that brings me to my second question. And I know that, my lord, this might sound new or out of place, but I request my lords to indulge me for 2 minutes by the watch on this argument. My lords, this debate.
You have to conclude within 2 minutes.
My lords, hear me. Allow me 2 minutes to. If my lords entertain this argument, I will go forward with it. But I need to speak this argument and speak my truth, so to say. My lords, in this debate between the legislature and the executive, the question is, I say this with respect, that the citizens of India are not a sitting duck. For example, just one illustration in the interest of time. I come up with a list of illustrations, but just one illustration. Well, let us say I come from an area where for around 100 kilometers, there is no government hospital or no government college. As a citizen in a democracy, I petition the government. The government says, I do political lobbying. I use all my democratic means. The government says, yes, we have passed the bill. And then it sits with the governor or on the governor's desk. At this time, my government or the political party in power, whichever, turns to me and says, we have done what we need to do. Now, at this point, if for the next 3, 4, 5 years, if that bill does not pass, then as a citizen, I have absolutely no voice. So it is my proposition that this advisory opinion, 5 judges bench, my lords, is also an opportunity to perhaps consider that it is time to recognize right to time as a concomitant right under Article 14. My lords, if the governors or the presidents do not act as constitutional functionaries in the time threshold that they're required to, irrespective of specific timelines, because we have said as soon as possible is a higher threshold, then my lords, it is an arbitrary act. And we have a series of judgments saying that arbitrariness and equality are sworn enemies. My lords, I have referred to a lot of judgments. I will just read one judgment, my lord, on this. My lords may kindly have.
When ready to just tell us the pages.
Yes, my lords, page number 1216. I'm just going to read it. My lords, Article 14, I'm reading Maganlal Chaganlal because, my lords, this is a 7 judges bench judgment. Article 14, page number 1216, last line, my lords, of my written submissions. Article 14 enunciates a vital principle which lies at the core of our republicanism and shines like a beacon light pointing towards the goal of classless, egalitarian, socio-economic order, which we promised to build for ourselves when we made a tryst with destiny on that fateful day when we adopted our constitution. If we have to choose between fanatical devotion to this great principle of equality and feeble allegiance to it, we would unhesitatingly prefer to err on the side of the former against the latter. I've also quoted Menka Gandhi right below, my lords, in paragraph 51, where we are saying Article 14 strikes at arbitrariness.
Go through it, yes.
Yes, yes. So, my lord, my argument is that if governors and presidents do not act in time, irrespective of that specific timeline, but they don't act as soon as possible, then, my lords, as a citizen of India, do I have no right? My lords, in multiple cases, right to privacy, right to media.
Thank you now.
My lord, just allow me just 1 minute to wrap my argument. Yes, my lords, 1 minute by the watch to wrap my argument. I'm only saying.
You have very well utilized your time. We have recorded your argument.
My lord, just one last argument. Right to time, I understand, is a major argument. It cannot be taken lightly because I'm requesting my lords not to just say something in the obiter. I am requesting my lords to say that right to time needs to be read as a concomitant right. It is about time. Otherwise, my lords, all these 4 categories of timeline will mean nothing, irrespective of how much pen and ink is drawn on the pages. Very grateful, my lords. Thank you very much.
Compliment for the young lawyer.
Yes, yes. They very well utilized your time.
Thank you.
Timeline was good.
I'll just take 1 minute at the end.
Yes, it's there.
Yeah.
That's your motto.
Lordship, I will start
Survey.
Next, yes.
only the new points, which are not discussed till now.
Yes, please,
Yeah.
tell us what are your news.
Yeah. In Article 361, President and governors are given protection in criminal and civil matters only, not in the constitutional matters. Now, by the virtue of the clause 1, proviso 2, if any constitutional wrong is done by the president or the governor, then the president or governor will not be prosecuted or punished by this honorable court, but the prime minister with Union Council of Ministers would be prosecuted and punished by this honorable court for any constitutional wrong. Second, in this constitutional court have power not only to correct the constitutional wrong, but also to prosecute and punish the persons liable for that constitutional wrong. It is the hidden power which our constitutional makers provided in Article 361 in Proviso 2. Now, our constitution makers never want that India should be governed by a dictator or the Hitler type of person. Because, Lordship, I will take only 1 minute in the constitutional history of that proviso. Our constitutional makers also seen the Second World War at that time, and they are also affected the devastating effects of that. The Hitler was also the one reason of that war at that time. I am not going the plus and minus of any politics. I am just saying only 2 things regarding the Hitler that are directly connected to this proviso.
Is there any discussion in the Constituent Assembly debates with regard to Hitler?
Lordship, it is connected to this constitutional court power, so that's why.
Is there any debate?
Lordship, it is just, you can say, when I will speak, it is the intention of our constitutional makers and they are totally affected, and it is also in certain political and constitutional books, it is also mentioned. What I will say in 2 or 3 lines only. Hitler was the political leader. He was not a dictator initially. In Germany at that time, there was a Nazi party. He was elected to the leader of the Nazi party in the democratic way and become the chancellor by the Hindenburg. But at that time, he kills the democracy in his own political party, and suddenly he misused all the parliamentary and the constitutional provisions and misused them and become the dictator in the Germany. Our constitution makers who borrowed the constitutional provisions from the different world countries also have the fear at any time can it be possible in the Indian democracy, can a leader elected by the democracy and by the votes can be converted into a dictator? Can it be possible? That was the question also in their mind. So that's why they provided this provision. This constitutional court have no.
Veda and the learned, please don't interrupt. He gets disturbed.
Look, we are internally discussing, my lord.
Don't
For
discuss
the
that
first
also.
time in the history of this court,
Yes.
Hitler is, my lord, coming
Yes, yes.
according to the need of constitutional
Lord, it's
interpretation.
taken our time, so please.
Yes.
Please, can I continue?
Yes, conclude.
Lord, sir. So the constitution, we have the democracy, and our constitution makers have the fear that one time can any elected political leader can be converted into a dictator. So that's why this court have the power under Article 142, that is the inherent power, that is a different thing. They also in this provision provided this power to this constitutional court. And even now there can be the question, then who can come to this court? And by the virtue of this provision, any Indian citizen, any person can come to this honorable constitutional court. And it is not necessary that a political party should come. It is clearly mentioned in this provision.
So who is saying that no person can come? Who is saying that a citizen is precluded from coming to the court?
Provided further that nothing in this clause shall be constituted as restricting the right of any person to bring the appropriate proceeding against the government of India and the government of the state. So that's why. If I can give the one example. If in 20 or 25 states, the government of the one party, and in the 4 or 5 of the opposition party, and if the continuous rule of the particular person is going on years and years, decades and decades, then what will happen? Who will bring out from the clutch of that person this constitutional? There are citizens of two types who cast the vote, and second, under the 18 years and the children in the womb of the mothers, they also have the right to the democracy.
You have 2 more minutes.
So Lordship again. Now the clause 1 is limited when it says that the president or governor shall not be answerable in the court. Never means that power or duties of the president or governor cannot be explained or defined, or vacuum cannot be filled, or writs cannot be issued by this honorable court. That means these writs can be issued to the president and the governors regarding their acts, duties, and the rights. That is the constitutional explanation of the Article 361, which are left. And now, Lordship, I will come to Article 111. In that, I will touch only one thing. Indian president have the power of pocket veto only in one condition. If the central ministry is shaky or is about to collapse. Not in any other case. Suppose if an ordinary bill is passed by the parliament and the president have the reason that it will collapse shortly, or the government have not majority in the house, in that case, he can use the pocket veto and keep the bill on his desk indefinitely, otherwise not.
Not indefinitely, till the new assembly.
The new assembly or the new parliament will come, and that will take the decision on that.
Thank you, Mr. Chairman.
Lordship.
No, thank you, your 10 minutes of order. Who is
Grateful
next,
to all.
Mr. Sajdeva or?
My lord, I'm appearing in IA number 198588. My lord, I have filed a petition in Chhattisgarh High Court on the same issue, that one bill passed in 2022 has not been either declared assent or nothing has happened, just sitting over it. So I have a locus here also. So my lord, most of the things have already been covered.
Yes.
What I would like to point out that there are 3 principles. Constitution is supreme, will of people must prevail, and rule of law. So the rule of law requires enactment of new laws. And that is, in my humble submission, is an essential and urgent business, urgent function. That is why the provision of promulgating ordinance is provided in the Constitution. So a law which cannot even wait for a house to sit and decide if in a given emergency situation required, then it could be promulgated under Article 123 and 213. So there is a time limit. The essence of time is there because these articles are there. You don't even wait for a house to sit and pass. Now, on Article 213, there is only one proviso in the main part, which requires precedent consideration, precedent recommendation. There is no corresponding proviso as regard to Article 200, the first proviso, which gives withheld. So something which is not there in 213 and there in 200 can't be interpreted in a manner to provide a pocket veto or withhold indefinitely. Just suppose a situation, an ordinance is passed, promulgated, and after 4 months, House sits, pass the same bill, can governor withhold? No.
That is already been argued. If you want to argue something, you will tell us.
Just my lord. The second thing is as soon as possible. The question query has came.
He has very beautifully argued just before you.
The query has come
As soon as possible.
that in as soon as possible, the suggestion with regard to not later than 6 months is not agreed. My lord, may kindly have a look at Article 62 and 68, which is with regard to election of president and election of vice president. In 62(2), when a casual vacancy occurs, the article says as soon as possible, but not later than 6 months. But in the case of 68, the election of vice president, the article says as soon as possible only. Does it mean that election of vice president is less important? As a matter of fact, vice president chairs the Council of State, Rajya Sabha. The session may be within next month or after 2 months. So this as soon as possible shows more urgency. It doesn't allow you to sit for 6 months.
Yes.
And my lord, the electoral college is also made different for this. The president electoral college involves legislatures, whereas the vice president electoral college is limited to only 2 houses.
How is that relevant in this?
Because the election has to be completed in a sooner better. I am just substituting my earlier argument. As soon as possible shows more urgency where it is used only without any time period. So in Article 200, when it was not agreed to, not later than 6 weeks, it doesn't mean that because after passing of bill, there are instances when in 2 days, 3 days assent is given. So my lord, the next point which I would like to raise is with regard to providing timeline. An example was given that trials ke liye timeline was given but it couldn't be adhered. Trial can go on, and this court has to grant time extension. That situation is not akin to this example. In my humble submission, a trial is akin to when the bill is in the assembly. It could be passed same day, it could be sent to some select committee. So we cannot assume in how many days the assembly house would pass the bill. But once it is passed, the situation is akin to reserving the judgment. And my lord have provided that within 3 months after reserving the judgment. And this timeline, because in the whole scheme of the constitution, 5 years for assembly, 5 years for president, vice president, Lok Sabha. There are instances as 2020 bill passed in some state and is still pending. And what is happening in my state of Chhattisgarh, one bill passed with regard to change of university name. Just the change of name that was not given assent. My lord, the third aspect is whether the petition 32 is maintainable.
Are you a state government?
No, my lord. What
Its condition is this petition at the case of the state
what I'm trying to say, I'm just addressing that aspect. Once my lord holds that withhold simpliciter is not there, that is the key. If my lord holds that withhold simpliciter is there, then everything goes. Once my lord holds that withhold simpliciter is not there, then the Council of Ministers advice has to be followed, except in the second proviso, what is there in the 200. Even in case of repugnancy, Council of Ministers recommendation is required to send to President. That is my submission. What I am saying, that violation of Constitution is ground for bringing impeachment for President. But there is no impeachment provision for governor. Governor holds office at the pleasure of President. That's all. Then if bill is not given assent to, then it's a violation of Constitution. Then what is the remedy? And
So you can conclude with your 1 minute here.
my lord can add that if not state, then leader of the house in the representative capacity can file at 32 petition.
Just
Yes.
not I've taken permission for Andhra
But
Pradesh.
I'm extremely grateful, my lord.
Thank you.
Not an issue, we have supported the union in all stands, except and including the stand that Article 32 may not lie against the governor. But to say that 32 will not lie in all cases by state law, that is something which we cannot countenance, because water issues, pollution issues, man-made disasters, and writs are pending. So let that issue not be gone.
At the outset, my lord, I must say that it is not the contention of the central government. It is not A versus B. My lord, some of the states have filed their reply that state opposing the reference. There is neither supporting or opposing the reference. Questions are put. So I am answering those questions that this is our interpretation. My interpretation is not that it is an absolute and unbridled right of the governor to sit endlessly for no reason on a bill. That's not the high-pitched argument which the central government would like to raise. B, the governor does have 4 options, my lord, to which I will not labor much. Because, my lord, after having learned, my lord, heard, my lord, the illuminating arguments of Mr. Sibal, Mr. Subramaniam, Mr. Datar, I've also gone through the note of Dr. Singhvi, etc. Lord, substantially, Lord, all of us have covered, except, my lord, points where they somehow missed, my lord, some of the judgments, etc. I'm not going to repeat any of the judgments because I know I am at the stage of rejoinder. I have filed my written.
So, Gopal Singh, Sangana Rao said there is no question of rejoinder.
Anyway.
You are saying this is only a reference.
I'll not enter into that debate, my lord. It's unnecessary, my lord.
Technically, he's right. Technically, he's right. Technically, he's right. But I think, Malad, because the issues are complex, Malad, we have no. Your lordship should hear.
It's not a question of, my lord, my being a petitioner,
Yes,
they
exactly.
being a respondent, and therefore I am giving a rejoinder. It is a question of assisting the court that this is the view of the central government, this is the view of some state governments, these are the views of this another state governments, and if they have expressed certain views, their interpretations, Lord, then I am just reacting or responding to their, my lord. It cannot be taken, my lord, in that strict jacket rejoinder, reply, rejoinder argument.
Because it's not a list, my lord. Because it's not a list.
It's not a list, my lord.
Therefore, there is no rejoinder, but I think we should not object
list.
if the solicitor wants to.
It's only an opinion.
No, my lord.
Not binding on anyone.
Lord, I would not reduce.
It is a report.
But we have had the perspective of 2 extreme views taken and argued by the 2 sides.
Your lordships are
The
right.
balance, we will have to bring it.
Yes.
I think we have seen the extreme views from both
Correct,
sides.
correct, correct. My lords, your lordships may, my lord, find.
It's a very enormous task that we have.
Your lordships, my lord, therefore.
And the task of 18,000 pages.
That's, my lord, that's a Herculean task.
Unfortunately, there is no summer vacation in between now and 24th November.
Yes, my lord, there is none. My lord, and your lordships.
The attorney has contributed only very little part of it. I said, I have contributed only very little part of it.
Yes.
Pages have gone up to 25,000, not 18,000. 25,000. Volume 5.62.
But, my lord, to be fair to everyone, we have not, none of us, my lord, have cited all judgments which are placed on record. My lord, possibly they are placed on record in case, my lord, it is required to be cited.
We are told of constitutional silence.
Yeah, yes, my lord. My lord, volume 1.9 may be taken, my lord, and I can assure your lordships, I am not going to read everything. I'll skip most of the paragraphs, but they are my submissions, my lord.
Another volume, no?
Yeah, my lord, it's a
Rejoinder volume.
rejoinder volume, my lord, a response, or my lord, I have termed it as a rejoinder.
Rejoinder submissions on behalf of the solicitor. Got it.
So this is the central government's interpretation, I'll put it that way, to the interpretation canvassed by some of the state governments. My lord, and I would, my lord, respectfully say, I would not reduce the august jurisdiction of this honorable court, that is advisory jurisdiction, of a mere giving a report which is not binding, which is not worth a piece of paper. My lord, no. Your lordship's opinion, Lord, is a law declared, and I'll make that good. And your lordships can even declare, I'm repeating, your lordships can even declare that this particular judgment or the view expressed does not lay down the correct law. Your lordships can even overrule that. It's not just, my lord, a communication or conversation between the President of India and the Supreme Court of India. My lord, the President of India has, my lord, you may my lord, has sought your lordship's opinion, and your lordships are interpreting the constitution while giving that opinion. My lord, kindly come to page 746. My lord, these are the broad propositions, my lord, which are argued, and I'll deal with it, my lord, without repeating anything, my lord. And if your lordship finds any repetition, your lordships may, my lord, kindly tell me. I'll proceed further to the next point. My lord, the argument number one: governors have no power to withhold a bill in any circumstances whatsoever. Number two, the governor has no discretion in any circumstances whatsoever under Article 200, meaning thereby the moment the bill is presented before him, in every situation he is supposed to act in aid and advice of the Council of Ministers, meaning thereby, if I put it, paraphrase it in my own way, they have not argued in that way, that he is a postman with only two difference, that his car has a beacon and he has a bigger house. That's, my lord, constitutionally a flawed argument. Third, the governor therefore is not to apply his mind to the process. Well, this was an argument made. The action of the governor is judicially reviewable to the fullest extent. My lord, I have certain constitutional submissions to make, my lord, before your lordship, my lord, which I have already made, but some additional submissions, my lord, which I make, that it is not amenable to judicial review. Even if it is amenable to judicial review, it is not justiciable. And I'll give the reasons, my lord, in a nutshell. The governor is answerable like any other executive authority making any other routine administrative executive decision. My lord, this is again, my lord, in my respectful submission, constitutionally not correct, because as I'll show, my lord, from the scheme of the constitution, the legislative process starts from a particular article, my lord. Thereafter, it comes to introduction of the bill. Thereafter, how the bill travels, and it ends, the legislative process ends with the assent of the governor. Your lordships are aware, the governor is a part, he is a component of the legislative assembly, but he has no right to vote. He cannot preside over the meeting. But nonetheless, he is a part of the legislature because the legislative process commencing from introduction of bill culminates into the final step of legislative process under Article 200, when he gives his assent. And the last, the governor must act within a set time frame as provided for by the court, absent any constitutional provision. My lord, kindly turn the page over. My lord, I have, my lord, already narrated, but I am emphasizing, my lord, this oath of office, my lord, because your lordships are considering the powers, functions, duties, responsibilities, etc. of the governor. And there is one judgment which is not so far cited, for which, as a prelude, I would like, my lord, your lordships to see which oath the governor and the president takes, which is, my lord, these are the only two functionaries for which, my lord, this specially defined oath is, my lord, contemplated in the Constitution, Article 159. I so and so do swear in the name of God that I'll faithfully execute the solemn affirm office of governor of so and so, will to the best of my ability preserve, protect, and defend the Constitution and the law. Lord, my first respectful submission is that there are certain implied discretions, which I will come to, my lord, little later. And one of the implied discretion, my lord, would flow from his duty to preserve, protect, and defend the Constitution. Lord, now, please, my lord, come to Article 167, which is quoted at page 747. It shall be the duty of the chief minister of each state to communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for the legislation, to furnish such information relating to the administrations of the affairs of the state and proposals for legislation as the governor may call for. He can even ask this how this particular government is functioning. And I'll, my lord, show Supreme Court, as your lordships have said, why this is the power conferred upon you. See, if the governor so requires to submit for the consideration of Council of Ministers any matter on which a decision has been taken by the minister, but which has not been considered by the council. He can say that such a decision of this magnitude, decision affecting the entire state or decision affecting the economy of the state could not have been decided by one individual minister, place it before the cabinet. Lord, these are the responsibilities of the Honorable Chief Minister of the state. Lord, now in this context, please read the Constitution Bench judgment which is so far not read, my lord. That is case of BP Singhal versus Union of India. Page 748, my lords. Lord, your lordships may see para 35 of this judgment. My lord, last line, which nothing, my lord, says much, it says the constitutional position. He thus occupies a high constitutional office with important constitutional functions and duties. Now, please see further. In state of Rajasthan versus Union of India, my lord, please mark, this is a 7-judge bench judgment. A constitution bench of this court described the proposition of the governor thus: the position of the governor as the constitutional head of a state, as a unit of the Indian Union, as well as the formal channel of communication between Union and the state government, who is appointed under Article 155 of the Constitution by the President by warrant under his hand and seal, was also touched in the course of arguments before us. On the one hand, as the constitutional head of the state, he is ordinarily bound. Please mark, my lord. The argument was that he is always bound. 7 judges bench says ordinarily bound by reason of a constitutional convention by the advice of his council of ministers conveyed to him through the chief minister, barring very exceptional circumstances, among which may be pointed out by my learned brother Justice Bhagwati and Justice Krishna Iyer in Samser Singh case, a situation in which an appeal to the electorate by a dissolution is called for. On the other hand, as the defender of the Constitution, this is why I read the oath he takes, as a defender of the Constitution and the law and the watchdog of interest of the whole country and well-being of the people of his state in particular, the governor is vested with certain discretionary powers in exercise of which he can act independently. One of his independent functions is making of report to the union government, on the strength of which the presidential power under Article 356 of the Constitution could be exercised. Insofar as he acts in the larger interest of the people appointed by the president to defend the Constitution and the law, he acts as an observer on behalf of the union and has to keep a watch on how the administrative machinery and each organ of the constitutional government is working in the state. Unless he keeps such a watch over all governmental activities and the state of public feelings about them, he cannot satisfactorily discharge his function of making the report which may form the basis of the presidential satisfaction under Article 356(1). My lord, here the 7-judge bench reads the implied discretion that under certain circumstances, as a watchdog, as a representative of the union, as a representative of the president, he will have to have certain discretionary powers, and one of the illustrative power is Article 356. Lord, further, Lord, this BP Singhal cites state of Karnataka. Lord, another 7-judge bench judgment. Lord. The governor of a state is appointed by the president and holds office. By state administration is carried on by him, etc., etc. My lord, your lordships may, my lord, kindly see. There are, my lord, your lordships can skip 38. 38. Another constitution, my lord, this is all quoted in BP Singhal. Another constitution bench of this court in Hargovind Pant versus Raghukul Tilak. My lord, please see, my lord, only the highlighted part. My lord, I have quoted everything so that I am not accused of selectively quoting, but what is relevant for the present purpose would be, my lord, in my submission, the highlighted part. The governor is the head of the state and holds a high constitutional office which carries with it important constitutional functions and duties, and he cannot, therefore, even by stretching the language to a breaking point, be regarded as an employee or servant of the government of India. My lord, not in these words, but my lord, Dr. Singhvi virtually said that he is just, my lord, a nobody who is sitting there on behalf of Union of India. He is not amenable to the direction of the government of India, nor is he accountable to them for the manner in which he carries out his functions and duties. He is an independent constitutional office which is not subject to the control of government of India. He is constitutionally the head of the state, in whom is vested the executive power of the state, and without whose assent there can be no legislation in exercise of the legislative power of the state. Grant of assent is exercise of legislative power of the state. And this would be relevant, my lord, when your lordship are pleased to examine the justiciability and locus of filing writ petitions, which is conferred by, my lord, this honorable court. There can therefore be no doubt that the office of the governor is not an employment under the government of India, etc. 5 is important. It is impossible to hold that governor is under the control of the government of India. His office is not subordinate or subservient to the government of India. He is not amenable to the directions of the government of India, nor is he accountable to them for the manner in which he carries out his functions and duties. Then, my lord, Rameshwar Prasad is quoted. My lord, this is again, my lord, constitution bench, but I'm skipping para 39 and directly coming to para 40. My lord, this would be, my lord, assisting your lordships, my lord, immensely. It is thus evident that a governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of his council of ministers. My lord, I am not disputing. Normally, ordinarily, the governor will have to act in aid and advice of the council of ministers. As, my lord, stated by Mr. Singhvi, he is not a super chief minister, neither expected to be super chief minister. That's not the role envisaged under the constitution. The first is that of a constitutional head of the state, bound by the aid and advice of his ministers. The second is to function as a vital link between the union government and the state government. In certain special emergent situations, he may also act as a special representative of the union government.
That is during the period of emergency.
No, my lords. My lord, I'll just give an example. I was going to give an example, my lord. A very, very good example. If we take away, if your lordships, my lord, read that there is no discretion, what happens? I'll take, my lord, there is one reference regarding Punjab water dispute. My lord, in Punjab water dispute, an agreement was entered into by Government of India, State of Punjab, State of Haryana, State of Rajasthan. The part of the water was going to Pakistan also, so it had, Lord, cross-border implication also. It had federal issues also. It was affecting more than one states also. That agreement was sought to be, Lord, cancelled by way of an act of the legislature. That now the legislature says that we will not be bound by this agreement. The governor, Lord, granted his assent. Kindly see, my lord, if discretion is not read, what would happen? Thereafter, my lord, State of Punjab filed a suit. Well, I'm giving a brief idea, my lord. I'll read some of the. Can I read it now, my lord, so that your lordship's question is answered, my lord? Kindly have a look at, my lord, that State of Punjab judgment. Volume 5.24, page 9357. But ultimately, what I am suggesting is that in a situation of this nature, he is not only entitled, he is duty bound to withhold the asset or refer it to the president. And that Council of Ministers will never advise him to do. Lord, kindly see para 2. Lord, this is the reference. Lord, at page 9360. Lord, this is quoting, Lord, ultimately the Honorable President made a reference to your Lordships, Lord, that under these circumstances, what will be the correct position of law? Lord, please see third, whereas while at the time of signing, I'm sorry, 2. I'm sorry, my Lord, it's my page, starts at page 9357. I am at 9360. The beginning, para 2, the second recital. Whereas the Indus Water Treaty 1960 was entered into between the Government of India and Pakistan on 19th September 1960, under which India is entitled to the free unrestricted use of water of Ravi, Bias and Satluj till they finally cross into Pakistan. Whereas while at the time of signing of the said treaty, the waters of Satluj had already been planned to be utilized by the Bhakra Nangal project, the surplus flow of rivers Ravi and Bias over and above the pre-partition use was allocated by agreement in 1955 between the states concerned, Punjab, Rajasthan, Jammu and Kashmir. My Lord, Punjab was undivided at that point of time. My Lord, please come to page 9361. Thereafter, my Lord, Haryana was separated from Punjab, and my Lord, another agreement comes. Whereas the state of Punjab, Haryana and Rajasthan entered into an agreement dated 31st December 81. I'm sorry.
December 1981.
Yes, my Lord.
Based upon that, suit was filed, suit decree by Supreme Court. And to get legal out of that suit, the Punjab passed this act.
First, my Lord, first act was passed. Thereafter, your Lordships are right, another act was passed. Lord, Punjab, Haryana, Rajasthan and Delhi. Lord, there was an agreement that this is how the water would be shared. Now, please come to para 5 at page 9363. Lord, the state of Punjab, Haryana and Rajasthan entered into an agreement dated so and so, which has been referred to herein above in the reference, by virtue of which the Punjab, Haryana, Rajasthan, in view of overall national interest and optimum utilization of Ravi and BS waters, had agreed on relocation of Ravi and BS waters, but as the said agreement was not being acted upon by the state of Punjab, the state of Haryana had instituted suit number 6 of 96 before this court under Article 131 of the Constitution of India. Now, para 7. The state of Punjab did, then there was a judicial order passed by your Lordships in 131. In the suit filed by the state of...
Was decreed.
Yes. Now, please come to...
January 2002.
My Lords are right. Para 7. The state of Punjab did not comply with the decree dated so and so.
Justice Venkatramaya Malaz presided over that tribunal, the Ravi Bias tribunal. And Malaz Haryana got a share, as your Lordship knows, not implemented by Punjab, which resulted in all these suits, Malaz. That's what really happened.
Lord, para 936.
Nani Palkiwala and I represented Haryana.
Lord, para 6.
Punjab was represented.
Lord, para 12 may kindly be seen. At this juncture, we would like to refer to certain unwarranted developments which took place after we started hearing this reference. The legislature for the state of Punjab introduced Punjab Satluj Yamuna Link Canal Land Transfer of Proprietary Rights Bill 2016. No assent of the governor is received till date. He is under a, my lord, not only entitled, he is under a duty in a circumstances like this not to give assent. Date, and therefore it is not a legislation and will remain a bill passed by the Legislative Assembly. By virtue of the aforesaid legislation, the state of Punjab proposed to act in clear violation of agreement dated so and so, which has been referred to in the reference. Lord, thereafter, my lord, the court says that this ought not to have been done, and non-grant of assent was approved. Lord, these are the circumstances where it is not possible to act merely on the aid and advice of the Council of Ministers. He is under an obligation to defend the Constitution, to preserve the Constitution, to act in his own discretion, and not to grant, my lord. Thereafter, my lord, he refers this to the President, and the Honorable President, my lord, gives, my lord, makes a reference. Now, my lord, coming back to my submission, my lord, at page 750.
You are relying only on this part of the.
This part, my lord, that sometimes, my lord, there can be circumstances where you will not get aid and advice, my lord, and I am not saying that every Council of Ministers would act mala fide.
Context with the question referred. Is there any question referred which is of any relevance to us?
No, my lord, it was apropos my lord's question.
No, we are just asking, in this context, is there anything relatable to this in the questions referred at 9363?
936, yeah. Look, these are the questions where, my lord, fact specific of that case,
President referred.
whether the Punjab termination of agreement and the provisions thereof are in accordance with provisions of the Constitution of India.
That's the first act.
Yes. Whether the Punjab termination of agreements and the provisions thereof are in accordance with provisions of Section 14 of Interstate Water Dispute Act, Section so and so. Look, this was a case where federal issue was involved, rights of other neighboring states was involved, cross-border implication was involved, etc. And your lordship's pendency of the suit before your lordships, and the judicial order was involved. And the government of the day, but I am not saying that the Council of Ministers would always act mala fide, but the government of the day, considering the situation prevailing at that point of time, would never advise the governor not to grant assent. He will have to, under the circumstances, preserve and protect the Constitution on his own discretion. Lord, that is the respectful submission. Then, my lord, para 40. It is thus evident that governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of the ministers. The second is to function as a vital link between union government and the state government. In certain special emergent situations, he may also act as a special representative of the union government, like in Punjab. Not only, my lord, in 356. He can ask the president that there is something being done which will have implications on the neighboring countries also and other states also. That is the emergent situation, my lord. Inter alia 356. He is required to discharge the functions related to his different roles harmoniously, assessing the scope and ambit of each role properly. He is not an employee of the government, nor the agent of the party in power, nor required to act under the dictates of political parties. There may be occasions where he may have to be an impartial or neutral umpire where the views of the union government and the state governments are in conflict. Please mark this. His peculiar position arises from the fact that the Indian Constitution is quasi-federal. Then, my lord, state of Karnataka, my lord, kindly read last 4 lines. Leaving the functions of the judiciary apart, by and large, the legislative and the executive functions of the center and the states have been defined and distributed. But even so, though it all runs an overall thread of or reign in the hands of center in both the fronts. My lord, pro-center tilt of the Constitution, my lord, as it is submitted or stated in many judgments. My lord, kindly turn the page over 751, para 44. My lord, again, this is, my lord, a reference of state of Karnataka judgment, my lord, which is, my lord, 7 judge. In such a scenario of myriad policies, ideologies, agendas, in the shifting sense of political coalitions. Well, kindly see the prophetic words used in reference to the governor's role. Myriad policies, ideologies, agendas in shifting sense of political coalitions, there is no question of union government having governors who are in sync with its mandate and policies. Governors are not expected or required to implement the policies of the government or popular mandates. Their constitutional role is clearly defined and bears very limited political overtones. We have already noted that governor is not the agent of the or the employee of the union government. As the constitutional head of the state, many a time he may be expressing views of the state government which may be neither his own nor that of the center. For example, when he delivers the special address under section article 176, it is always prepared by the Council of Ministers, the governor, the government. A reputed elderman, statesman, able administrators and eminent personalities with maturity and experience are expected to be appointed as governors. While some of them may come from a political background, once they are appointed as governors, they owe their allegiance and loyalty to the Constitution and not to any political party, and are required to preserve, protect, and defend the Constitution. See, terms of oath or affirmation by the governor under Article 159. My lord, almost, my lord, many judgments say that his duty has to be read in tune with the oath he takes. Like the president, governors are expected to be apolitical, discharging purely constitutional functions, irrespective of their earlier political background. Governors cannot be politically active. My lord, as I will point out a little later, my lord, we should be proud as citizens of this country that the Constitution and the aspirations of the constitutional framers have withstood, my lord, this expectation. I'll give, my lord, the empirical data. Irrespective of the government in power in the center, right from, my lord, 1970, irrespective of the government in power in various state governments, my lord, the governors, except few aberrations, have acted, my lord, the way the Supreme Court has desired them to act. Lord, please kindly now further see state of Karnataka, my lord. Again, Lord, I am reading at page 752, para 44. However, we may examine the express provisions of our constitution relating to the organs of government in states, which no doubt give the appearance of full-fledged separate states for certain purposes. Each state has its own governor exercising the executive power of that state. But all governors, although undertaking to devote themselves to the service and well-being of the people of their respective states, owe an undivided allegiance to the Constitution and the laws. This is where, my lord, the implied power comes, and exceptional circumstances where aid and advice they cannot follow if it is unconstitutional or contrary to the Constitution. Now, my lord, please come to para 753. Page 753. My lord, I am skipping. Lord, page 753, I'm not reading it. I'll just, my lord, point out orally. Lord, some of the submissions, Lord, compared the Honorable President of India under our Constitution but I think the expenditure which, my lord, either I was to bear or Mr. Sibal was to bear, Lord, should be borne by Dr. Singh.
That is why he always takes the corner seat, so that he can easily slip away.
Yes.
From
The
front,
reason
if he
being,
slips away, then everyone will notice
the
it.
reason being, the
Lack of natural justice, I don't know the context. Ex parte
but
comment.
you don't need to,
Ex parte comment.
you say, all right, I'll bear the expenditure. You don't need to know the context. Lord, because the other side nodal council is like my daughter. This side nodal council is like Mr. Sibbal's son. Mr. Sibbal's son also. So, my lord, I better, Dr. Singhvi, who has always been earning throughout this, my lord, reference, should bear the expenditure.
Sure. But in this matter, he is appearing for how many states?
Only one state. There are people appearing for more than one state here. But I am happy to share whatever expensive analysis says or bear.
Not share.
No, no, not fair.
Fair,
You have to bear.
not share.
Or bear themselves. Without asking about the details also.
No.
But I trust him that he
No,
won't be unfair.
I said that I'll bear it. Now, Mr. Sibbal said, no, I will bear it. Now you're reduced to sharing. This is not a soldier.
Tax exemption.
My lord,
Don't see tax
this
exemption.
is the third option, my lord. And
No, but that will be counted as an expenditure.
therefore, I was going to say this,
So he'll
that this option which is exercising would be referred to somewhere else.
No, he is the highest taxpayer.
Yes. Highest individual taxpayer. my lord.
Maximum brickbats for that.
Anyway, my lord, on the lighter side, my lord. My lord, Crown, my lord, some of them compared, my lord, only 2 minutes on this, nothing more than that. That President of India is like a British Crown. My lord, Mr. Datar even read some judgments that British Crown cannot withhold, cannot do this, cannot do that. My lord, we will have to understand, my lord, that our constitution borrows a broad skeleton of parliamentary democracy as available in England. We have not blindly followed it. Crown is a hereditary crown. Queen's son will succeed irrespective of his qualification or acceptability in the nation. He would be the king. While our president is elected by the entire nation by way of an indirect election, because his voters are elected people representing the will and wish of the entire nation. He is supposed to act as per the aid and advice of Council of Ministers, who are all again elected, and they owe responsibility and answerability to both the houses of parliament. This is the position of President of India, can never be compared with the crown, British crown. Lord, that is what I have elaborated. Lord, essentially, my lord, before I switch over to another topic, my lord, essentially, my lord, the governor's role will have to be as a guardian of the constitution, protector of the constitution, a representative of Union of India, a person who takes in particular or peculiar circumstances interest of the entire nation because he represents the President of India, and everything he should do in consultation and collaboration with the Council of Ministers. Lord, your Lordships would recall yesterday when Mr. K.K. Venugopal was arguing, Lord, he gave a list of dates in case of Kerala. And he in fact said that this is how it should function. I agree, fully agree with him, that the governor calls upon the chief minister over tea, some issues are discussed, thereafter, my lord, there is some other discussion, other meeting, other consultations. This is how, my lord, the constitution works, and this is how the constitution has worked. I'll show that with empirical data that this is how the constitution has worked. Now we are raising a false alarm that there is a need to do something, my lord, which I will, my lord, try and demolish. Now, my lord, please come.
How can you say that if the bills are pending before the governor for 4 years?
I'll answer that. It is a part of, it is a part of my submissions. I am not justifying indefinite pendency of the bills. I am respectfully urging there cannot be any straitjacket timeline because each bill depends upon the facts of each case. I'll come to that and I'll show that such.
This we can appreciate, that there can't be any specific timeline. But your one line of argument is that he has a power to withhold the bill permanently.
Yes, Yes, my lord, that's my argument. That's my next point. That's my next point, my lord. In my submission, the governor, instead of referring the bill to the president in Punjab, he should have withheld it. That this bill can never be passed. And I'll give the empirical data right from 1970 till date, right from 1970 till date, as per the data available with me, only 20 bills across the nation are withheld by different governors. Out of 17,000 bills, only 20. So this is not a power, my lord, which is to be exercised at a drop of the hat, that I don't like it. It's not in tune with the political policy of the party in power in the central government, but something which is so atrociously unconstitutional.
It was withheld by stating that I am not giving an assent, or it was.
I am
just
withholding.
indicated?
I am withholding.
Therefore, he has rejected this.
Withholding is an option, and your lordships, my lord, may kindly consider.
You also have the data where bills are sent and not cleared for years.
My lord, I have the data which shows that 90% of the bills, the assent is given within 1 month. 90% of the bill. Then second column, I will come to within 3 months. The third column, within maximum 6 months. And more than 6 months are few.
See, when I gave lesser data for things.
No, you were on a
Give it.
state-specific
Giving
data.
empirical data now, this can't be allowed both ways. Please take my data also, but that's not fair. My learned friend objected very vehemently, even when I opened. And I am giving you actual live instances directly year by year for 3 states. It can't be one-sided.
Anyway, my lord, anyway.
Can't be
Bengal,
one-sided.
Malad, all the bills are more than 3-4 years, Malad. I didn't give any data because your lordship said don't give data. Now you can't give, Malad, all this is happening after 2014, not before that.
Oh, I'm so sorry. My learned friend possibly is not aware. I am praising your government also. 70, right? From 1970 till date.
I know that. You should praise because no governor acted like this. You're absolutely right.
No, I know, but
You're
but unfortunately, I am not a politician. I'm only a lawyer. So I'll not make any political
more of
comment.
a
No, I have
politician than I
many,
am.
I have
Don't
many
get into all
comments
this.
to offer, my lord, but I'll
get
be
into all this.
only a lawyer. But right from 1970 till 2025, which includes the period from 2014 to 25, only 20 bills are reserved. My learned friend was, my lord, wanting to give his state-specific problems. I'm not giving you the problems. I'm giving you the empirical data, how the constitution has worked since last, my lord, 1970, since last 55 years.
Maybe we are not going to go into that question.
No, my lord, I'll show that, my lord. It must be shown, my lord. Kindly, my lord, have a
No,
look
but
at.
then if it has to be shown, then we'll have to see that at all. No, it can't be one-sided.
Only, my lord, if the lordship ignores this, lordship may ignore this.
Because if we are not permitted them to give any data, you should also not give any data.
Lordships would immediately see.
But that's not fair.
Your lordships would immediately know the difference between the data they want to show. This is not, my lord, figures.
No, that's not fair.
My lord, would your lordships not like to even see to reject it?
If you objected to their sharing our data, then the same analogy should apply to you also.
Kindly give me 2 minutes, uninterrupted 2 minutes. My lord, give me.
Then we'll have to give them an opportunity to.
Please do that. Kindly, my lord.
Having objected that, now you can't turn back and say that I want to give the empirical data.
Kindly, my lord, appreciate something, my lord, which is.
No, you argue on the questions of law, but not.
I am
not
arguing on a
data.
question of law, but the empirical data suggest. My lord, give me, my lord, a minute. Your lordships can ignore this argument completely. My lord, from 1970, we received data only on.
Solicitor, it will not be fair to go into that question because.
Ignore it, my lords. Give me a minute, my lord.
Then why argue it? Then?
Give me a minute. Out of 25 states, right?
Forget, we will not go into that question. We will only answer the questions which are raised before us.
Lord,
Otherwise, then we'll be unnecessarily going into the data. Then we'll have to. Then-
My difficulty is I'm unable to communicate what I'm trying to communicate. They wanted to present their problem, that in my
Not
case.
problem. They wanted to present as to in how many cases their bills have been.
Your presence is noted for today.
Mehta, you need not be
They
unpleasant.
wanted to
You are
present the data
critical. You
in
oppose me
respect,
and now you're
in
doing the
respect
same
of the
thing.
states to which they are representing, as to for how many days and how many years the numbers of bills are pending as in with the governor. So you objected to that.
Lord,
So
please,
now, you objected to presenting such a data.
Lord,
Now
I
you
am,
can't say that I will present a data on the basis of all India and.
Lord, 90% of the bills are assented within 1 month.
Maybe.
How is that relevant?
Relevant for
today?
that,
Why are
determining the
you
question.
making that submission? Just
And only 20 bills out of 55 years are withheld, which includes these 7 bills.
nation is continuing with the constitution and the democracy for 75 years.
Yes.
Irrespective whether 50% bills have been
Difficulty is
withheld,
this.
90% bills have been withheld or whatever.
Well, Lord,
The
forget,
states are
forget,
also
forget the
functioning,
facts. I'll tell
citizen
you.
is also functioning. Leave that aspect.
Forget the facts.
We
Forget the
are,
facts.
we are proud of our constitution.
We are proud of the
When we see
constitution.
what has
my
been
lord.
happening in the neighboring states, like what happened in Nepal yesterday.
Yes, my lord. Yes, my lord.
Earlier Bangladesh.
Almost, my lord, yes.
Nepal, it just happened 2 days back.
I am, he argued felt necessities, felt necessities. His note
But
was.
then you are
little-
also bringing factual.
No, no, no. Felt necessities. He says these are felt necessities. So to respond to felt necessities in his bill, I'm saying that earlier also such kind of issues must be arising. But the states were not being advised to rush to the Supreme Court. They were settled. 1 month.
They were
90
ill-advised then. If they are better advised today, why should we go into that question? We are not going into that question.
Don't go into that question. But
What happened prior to 2014 and what is happening later after 2014 is not relevant for us.
We are only going to answer.
No, I'm sorry, my lord. My learned friend unfortunately brought 2014. My data is 1970 onwards. 1970 onwards.
Anyway, let us go.
It is
Let us-
government of India.
Mr. Solicitor,
For him, it may be
let us-
2014 and
let us
pre-2014.
Let us restrict ourselves to the.
Lord, I'll restrict it, but I strongly object to this kind of division.
No, I also object to what you said.
That 2014, what is
Politicians
this?
and
Both of you may record your objections outside the court. You may argue.
Lord, it's
Relevant
not in, we are one nation, my lord, one continuing government. Government is always in continuance.
Mr. Solicitor, the point is whether one bill is withheld in the past 1970 to 2025 or 1,000 bill withheld. That may not be relevant.
Whether power of withhold is there or not.
The power of withholding best or not.
This,
Power of withholding.
this
has to be the
fire in the auditorium argument that something is happening. Do something, felt necessity. Therefore, I am saying.
No,
there is
we
no
did not
necessity.
permit that argument to be made.
We
The
We did not permit them.
felt necessity was an argument
We,
which.
no, we did not permit them. We did not permit them.
That's why we
And
want
I leave it at that, my lord, I can't argue.
And when we did not permit them, we will not permit you also.
But your lordship did not. But he read that.
No, he did not read. We did not permit him to read.
No, not facts. I'm sorry, my lord. Phonetically similar words. Felt necessities, not facts. Felt necessities. That's what, my lord, he is arguing.
Leave it at that and start. after.
Yes, my lord. Now kindly come to para 15. Kindly come to para 15. Article 200 states that when a bill is, my lord, kindly see, my lord, when a bill is presented, the governor shall declare either that he assents to the bill or that he withholds assent therefrom or that he reserves the bill for the consideration of the president or return with the message. Now, my lord, the way they want to read it and way, my lord, the three-judge bench in Punjab has read it, if that is the correct interpretation, the article will have to be read with this amendment. Kindly see, when a bill has been presented so-and-so, the governor shall declare either that he assents to the bill or that he reserves the bill for the consideration of the president, provided that government may, as soon as possible, after presentation so-and-so, and last, shall not withhold, should be assent therefrom. Assent thereto. This is how it would read. my lord, kindly appreciate one thing and my lord, kindly, my lord, come back to my lord, my initial argument and compare it with their argument. My lord, their argument was, and this is my lord, very crucial point, my lord, in my respectful submission, that the word withhold is used in the sense of a temporary deferment. That I defer and return the bill to the House. Correct, my lords? The word withhold is used in the same article twice. First, he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill. Now I read it as they read it. Withhold assents to the bill, or temporarily defers the assent therefrom, or he reserves the bill to the president. And then, according to Punjab judgment, and it is their argument, that he will have to resort to proviso. My lord, what meaning, I'm posing a question to myself, we will give to the last part, my lord? If the bill is passed in the proviso, first proviso, if the bill is passed again by the House or Houses with or without amendment and presented to the governor for assent, the governor shall not withhold. Lord, this is definitely a final withholding. This withholding can never be a temporary deferment. One word used in the same article cannot have two different meanings. I hope, my lord, I am able to. I'll, my lord, again, my lord, kindly allow me to make myself more clear. My lord, your lordships may, my lord, read with me the first main part. When a bill has been passed by the Legislative Assembly, so and so, the governor shall declare either that he assents to the bill. Pause here for a minute. Now I am reading the way they read it. That deferment, withholding here is temporary withholding or temporary deferring till
The proviso is exhausted.
it is returned to the House. So I am reading it, or may temporarily defer or withhold the bill. Correct, my lords? So temporary deferment is withhold, according to Punjab judgment and my learned friends, my lord, very illuminating, my lord, contention. Now, my lord, what meaning we will give, my lord, apropos, my lord, Justice Narasimha's, my lord, query. Please come to the first proviso, last line. And if the bill is passed again by the House of or Houses with or without amendment and presented to the governor for assent, the governor shall not withhold assent therefrom. Lord, this withhold cannot be temporary deferment. It doesn't say that governor will have to assent. Lord, both the term withhold is used in the main part as well as in the first proviso. It cannot mean temporary withholding or temporary deferment in the main part and final withholding in the proviso. Along with, my lord, I have read, my lord, withhold months means it falls through and falls through, my lord, I'll come to that. My lord Justice Narasimha, my lord, also pointed out that this is not a word used in the Constitution. My lords are right. But the word falls through has a significant connotation even in the Constituent Assembly debates. When the amendment is not passed, they say amendment falls through. That is the expression very consciously used by the Constitution benches subsequently. That if it is withheld, the bill falls through, meaning thereby it ceases to be a bill. It will not become an act.
It is not passed by the Constituent Assembly.
No, I'm slightly on a different point, my lord. Maybe I'm going a little fast.
As far as constitutional amendments are concerned.
I'm not on amendment. Ignore that last. I'll come to that little later. Ignore Constituent Assembly debate part.
No, you said that
Fall through is coming
fall
from
through is
there.
coming from the Constituent Assembly debate. There it comes from the context that whenever any amendment is suggested, and if the amendment is not accepted, then that amendment falls through.
Meaning thereby it ceases to be.
It ceases to be. Yeah.
So that
But
phrase.
that analogy can be applied to the bill which is passed by the legislature.
Bill, kindly appreciate the distinction. The Constituent Assembly amendments were not to be approved or assented to by someone. Therefore, it used to falls through there. Here, there are stages. that it becomes a bill, then if it is assented to, nothing happens. But if he withholds, the expression which is used is borrowed from Constituent Assembly debates, that it falls through. I'll come to that, my lord, little later. My lord, now please see para 18, my lord, at page 755. The interpretation can be construed from a different angle if the word, my lord, I have already argued that, my lord, I will not trouble your lordships with that, my lord. Please come to para 21. My lord, the argument was that you take the spirit of the Constitution. Spirit of the Constitution, according to them, as understood by me, is that governor has to do nothing. He has to act as per the aid and advice. My lord, that violates the very fundamental principles that there are certain implied discretions which the governor can exercise. But to come out of that, they say that look at the spirit of the Constitution. Lord, my learned friend, my lord, I have requested him to, my lord, elaborate on that. But there is one.
For rejoinder, everybody will not be permitted.
I am in your lordship's sense.
Then you will give you time, but not everyone.
I am in your lordship's sense. Lord, I didn't object.
Suppose after the solicitor, then I have my final say on the matter.
We'll give you time till 1 o'clock tomorrow.
Yes, yes, Lord. Lord, all of us can conclude by 1 o'clock.
Not all of us. It can be a debate sort of. You are appearing for the center?
It will have to be a debate.
No, sorry. Whatever is the stand of the other states have already given their opinion.
Lord, come and sit here, my lord.
That privilege is only for Mr. Amit Kumar.
I'll not answer that, my lord. That's a separate privilege. Let it be, my lord. Let it be. My lord, this argument is debated in, my lord, this Keshav Madhav Menon versus Bombay in, my lord, 7 judge cases, 6 judges. 7 judges, my lord. I'm sorry. 7 judges, my lord.
Earlier judgment, some judgments were by 4 judges also.
4 and 6, yes.
Yes. No, this is my 7. I have said 6, but it's a mistake. Kindly, my lord, at page 756.
It is 7.
7. It is 7 judges. So please come to para 13 on that.
Yes.
An argument founded on what is claimed to be the spirit of the Constitution is always attractive, for it has a powerful appeal to sentiment and emotion, but a court of law has to gather the spirit of the Constitution from the language of the Constitution. What one may believe or think to be the spirit of the Constitution cannot prevail if the language of the Constitution does not support that view. My lord, the argument, which was a very catchy and very, my lord, kind of a, my lord, as they say, my lord, emotional argument was that the bill passed by the majority of the House. How can that be withheld or killed by one individual? Not if the textual meaning permits, it can be done. It is for your lordships to consider whether it can be done routinely. But I wanted to show that in 55 years, it is done 20 times. Various governments, various combinations, one party in center, another party in state, third party in center, fourth party in state. But Constitution has withstood. And there are circumstances where, as I have given the example, I'll give that example because when I come to that point, my lord, I'll give that example. My lord, kindly, my lord, turn the page over and come to para 24. Para 24. My lord, this is felt necessities. My lord, what I wanted to show from the empirical data that the Constitution with the present 200, with the present interpretation of 200 has withstood the test of time. 1 or 2 states recently, in the last few years, maybe because of the governor's inaction or for whatever reason, I'm not going into it. they cannot declare a felt necessity to amend the constitution. And even if felt necessity is there, the remedy is not to amend the constitution by a judgment. So please have a look at para 24. The argument of the other side on the issue of constitutional interpretation, specifically the reliance on felt necessities and purposive, non-conflict based interpretation, deserves a closer analysis. While the said submissions appear to be non-controversial and appealing, there exists an inherent contradiction in the submission advance. The following factors may be noted in this regard. It is submitted that felt necessities and purposive interpretation necessitate a collaborative and effective constitutional role for all authorities. The doctrine of felt necessities is a call to construe the constitution in a purposive, dynamic, and forward-looking manner. Thus, any constitutional interpretation ought not to immobilize one constitutional actor while exalting another. Look, collaboration is possible if I have some powers, my learned friend has some powers, and we sit together. I have no powers. I'm supposed to, according to them, act as only what he says. Then what collaboration? What consultation? Well, why have four options? Living and purposive reading supports a model in which constitution functionaries engage with each other in good faith to realize constitutional objectives. The felt necessities of our times, including frequent interinstitutional friction, reinforce the need for constitutional practice that enables reasoned consultation and principled participation rather than a one-sided insistence that any role other than a mere mechanical signature by the governor is impermissible. This is where I am suggesting a balance. They are on an extreme argument that governor is merely a signatory. He can do nothing on his own. But at the same time, they also argue that there should be a collaborative and consultative exercise. What collaboration and what consultation if I have to sign without anything at my discretion? And my lord, this has been going on since 55 years. The chief minister is called, the minister concerned is called, there are dialogues, there are debates, there are exchange of views. Sometimes, my lord, I'll just give you an example. A popular feeling in the state requires the legislative assembly to pass a particular bill, which even the elected leader knows that it's not in the interest of the state. They might advise the governor, my lord, informally to keep it pending till the situation cools down. They might request the governor to withhold that bill. Look, there are several contingencies, several situations, my lord, which we will not be able to identify, visualize, or illustrate. But going further, 26, it seems that having found either textually or contextually no other meaning is capable of being given, the states opposing the stand of the union makes a fallback argument of felt necessities and purposive interpretation. First, the term felt necessities is a subjective term. No subjective term can provide guidance for constitutional interpretation. The issues which have been arising in past with regard to the position of governor vis-a-vis the Council of Ministers have always been arising after the Constitution came into force. Such issues have not cropped up suddenly, which can permit any state to argue felt necessity. It is submitted that the Union of India fully accepts the constitutional proposition that the exercise of functions by the governor and the Council of Ministers must be collaborative and consultative. However, based upon perceived felt necessities of 2 or 3 states, which knock your lordship's door, rather than taking the correct political process, which so far has been adopted by all governments of all color. 2 or 3 states, it will not be permissible to interpret the Constitution so as to distort not only the text, but even the intent and purpose of Article 200 and 201. In the same vein, the doctrine of felt necessities must also be looked at through a different lens. It cannot be the case that the judiciary is the only organ to determine the felt necessities of time and interpret the law accordingly. The other co-equal organs also engage in a test of enacting and implementing the law according to the felt necessities of time. Therefore, the Parliament in its constituent power is equally well placed to amend the Constitution to meet the felt necessities of time. Lord, that does not mean, my lord, that every state would come before your lordships, reduce the highest judiciary of the country to, my lord, if I may be permitted to say so, the, my lord, position of a headmaster and say that this student is not doing it, tell him to do it. That's not, my lord, the role of this honorable court. There are political processes, there are consultative processes. The chief ministers of one particular color would go and meet the president of India, would go and meet the prime minister of India, and problems are solved. More and more cases are not coming before your lordships, not because problems are not arising, but because the problems are solved the way in which in a democratic polity they are required to be solved outside the courtroom. Now, therefore, I say that 90% of the bills are passed, assented to within 1 month. And if I go total, Lord, almost 95+% bills are passed in 3 months. Right from 1970 till date, my lord, 55 years. This is how the Constitution has operated. My lord, then there are some foreign judgments, my lord, which I will definitely skip. Because there are certain things, my lord, which makes the larger bench incomplete. My lord, this is one of them, my lord, citing of judgments of other jurisdictions, my lord, which I'll skip. But then argument was that you please give the interpretation to the Constitution to make it workable. And according to the states, the workable would mean giving status to the governor of mere signatory and becoming an ornamental head of the state. Though, my lord, I have pointed out that the chief minister is under a constitutional obligation to go and tell him what is going on. The governor can call him and ask him what is going on. There are 4 options, my lord, which all larger bench judgments, my lord, have said that these are the options available. And the very fact that options are available means options are available to the governor. Options are not available to the Council of Ministers. My lord, if there is a repugnancy, apparent repugnancy, my lord, which Council of Ministers would advise the governor that no, there is a repugnancy, don't give assent to the bill? He will have to, my lord, in exercise of his duty to protect and preserve the Constitution, say that no, I cannot assent to this bill. My lord, please come to the next page, para 35. My lord, I am skipping those paragraphs, my lord, which I am paraphrasing in nutshell, so that, my lord, others can, my lord, assist the court. 35. The argue.
There is no one to assist the court except you and the attorney. Otherwise.
Two of us, my lord. But it was not, my lord, my.
Otherwise, those states will say that we will also say something in rejoinder.
When I say other means other than me, my lord, but the learned attorney, my lord, that's not.
So you said others. So
you want to include the others on your left, huh?
My lord, my difficulty is they do not understand, my lord, how to get a right of hearing. They are sitting at the wrong place.
No. We have given them all of them. We have given them only what opportunity.
Not, my lord, I could not convey the humor, my lord, what I wanted to convey.
It is except Mr. Amit Kumar who.
Anil Kumar is not the subject matter of my humor.
Amit Kumar.
Amit Kumar is not the subject matter of my humor, my lord. I could not convey, my lord. I'll convey it at a later point of time. Let's leave it at that. Lord, para 35. To argue that collaboration requires one organ to have no meaningful input is contrary to the very idea of discussion and dialogue. It also misunderstands that collaboration can occur only where there is a space for reasoned consultation and the articulation of principled disagreement followed by resolution. It is further submitted that the collaboration or dialogue can never be one-way street. It can only work if there are two co-equal branches of constitutional actors who are willing to listen to each other and are mutually committed to such a collaborative exercise. The governor, you have to do nothing. You are a postman. Whatever we tell you, you either grant assent, then sign it. Withhold assent, sign the withholding. Return it to the house, you return it. Refer it to the president, you refer it. And then, my lord, every judgment says that the exercise should be collaborative exercise. My lord, therefore, I say collaborative exercise necessarily imply co-equal constitutional organs. There cannot be, my lord, imbalance of functions, but I'm not saying power imbalance. But one has nothing to say and another has everything to say, then there is no collaboration, there is no consultation. It is submitted that further the office of the governor carries a limited but real space for statesmanship with constitutional bounds. My lord, kindly read, my lord, this is what, my lord, your lordship, my lord, this is what Justice Narasimha said, that both sides have given extremes. Lord, I am just giving, my lord, kind of a neutral interpretation as according to me. Ultimately, what your lordship decides would be the neutral. But this is how, my lord, I perceive the constitutional scheme to be. Anyway, my lord, I have learned to ignore, my lord, certain things. It is submitted further that office of the governor carries, because I wanted to say, my lord, laugh something, my lord, after giving some incident in 70s, but I don't want to go into it. Let us be constitutional debate, my lord. Yes. I don't want to contest elections. The Constituent Assembly's expectation that the governor would function as a friend.
The outcome very soon, Malate, we did.
Pardon?
I said, I wish you do contest elections one day.
No, it's very difficult. My lord, I know. In Lok Sabha election, it's, my lord, we may say that they are politicians. To contest a Lok Sabha election is very, very, very difficult in the present times, my lord. The voter is a very smart voter, whether he is a doctorate or he is an illiterate farmer. Nobody can be taken him for, nobody can take him for a ride. And that is, my lord, the strength of our democracy. Kindly, my lord, appreciate, and I always feel proud of it. When Mrs. Gandhi imposed emergency, not a political argument, Lord, the people, Lord, they always, the name, my lord, agitates them. Lord, when they, but I'm going to say something other than that. They'll make them happy because I'm neutral. When she imposed emergency, the people, my lord, taught such a lesson that not only the party lost, she lost her seat. Janta government came. They could not manage the government. They could not manage the administration. The same people, within 3 years, dethroned them and brought Mrs. Gandhi back.
With a thumping majority.
With a thumping majority. Look, this is the strength of our democracy. I was not doing a political thing, my lord. Why get shaken when, my lord, some name comes or some surname comes? It's not always political. I'm saying this is the strength of the democracy. Lord, we may have aberrations. We may have some governors, my lord, who may have, my lord, not discharged their functions as expected of them. But since 55 years, as per the empirical data which is available, my lord, everyone has acted the way they are expected to act in a collaborative manner. And the best example was during COVID. Except, my lord, 1 or 2 states I'll not name, my lord, all states, Congress chief ministers, communists, everyone, they were on the same line. They were directly in touch with the Prime Minister and they were fighting the, my lord, crisis as a nation. So, my lord, we have a strong democracy and there are political dialogues, there are, my lord, political discussions and there are political solutions. But somehow, my lord, there is a trend, my lord, that now everything comes here. Now, my lords, may kindly see, my lord, after skipping through the Lord, please come to page 765. Lord, I am arguing this, my Lord, my proposition is this, my Lord, that interpretation which amends the constitution, I'm sorry. अभी मैं वहां आया नहीं, not come there. ये नहीं करना है, next. Lord, 765, I'm not reading the judgment, but it says that A, I'm just giving the proposition, my Lord, I'm not reading the judgment or my Lord, my submissions. Textual meaning, if clear, textual meaning is always preferred. Yes, first principle, my Lord, first principle of interpretation. Second, even in case of felt necessities or some extraordinary situations at times, your lordships would not interpret a constitution which even remotely has the consequence of amending it. So there are judgments, my Lord.
Certainly consider the interplay of 200 and 201 coupled with the sabbatical one and its proviso 1, proviso 2. These are very clearly interrelated. It is not a felt necessity issue. It's an issue. Constitution is a evolving subject, number one.
It's a living document, therefore they say yes.
Number two, not in the context of felt necessity as in an administrative law situation. In the constitutional concept itself, how do we gauge this proposition that you advance that at the outset the governor can straight away say that sorry, we will not assent to it. Withhold, in other words, the meaning you are saying, not to assent. So the moment the assembly passes the bill, it comes to the governor, he says, I will not assent to the bill. That to be interpreted in the context of two intervening principles. One is the principle of federalism and the principle of democracy. In that context, we need to balance. Both are as important as. There won't be an expression of a federalism written in the constitution, nor about democracy. How do we give the full import to a bill which is passed by the houses?
Yes.
And comes to the governor and solitarily he stops, or is there an obligation to ensure that a consultative process takes place? That when the bill comes to the governor, he could send it back with a message, and it gives assembly as well as the governor both get the recognition of their role to play. It goes back to the assembly. Assembly considers the perspective of a governor who is reflecting perhaps in all probability the view of the center. And it goes back, assembly reflects on it, comes back. When it comes back to him, how do you read that position that shall not withhold?
He can still
Now,
refer.
nobody has addressed on that question as to when it comes back, he loses that opportunity to send it back to the president.
No.
Or it is just a thought.
I'm sorry.
Just a thought. So do we also read 200 and 201 together?
We should.
Full flow.
Correct.
Even if it goes back to the president at that stage, he can't say no. So look at the beauty of the constitution. Even if in the second round it goes to the president can't say I will withhold it. President will have to say that he can assent or he has to compulsorily send it back.
But
when it goes back to the assembly and comes back again to the president, the constitution is beautifully silent. It says that it shall be presented again to the president for his consideration. Full stop.
The buck stops.
Silence of the constitution, enormous meaning it has.
Yes.
It carries. It is in that silence much more is there.
Yes.
But to say that at the outset, the moment the bill is sent to the governor, He says, sorry, I will return it back. It's a very difficult proposition to
Yes, well,
accept.
let me answer that. Let me answer that straightway. Lord, once, Lord, kindly take a hypothetical situation. And Lord, I'm aware of the argument that extreme examples are given by me. But before that, Lord, let me preface that. Lord, Constitution, I'm sorry, Lord. Lord, the constitutional interpretation has always been made based upon hypothetical and extreme examples. So when I answer the question, there would be some extreme example, but I want to give a prelude to that. Lord, when Keshwanand Bharti was being argued, and this is reported, my Lord, I'll cite from that judgment also. The initial reaction, and my lords are aware, my Lord Antyaru Jina, who assisted my Lord Mr. Surya, my Lord, he has written, it's a first-hand account.
Making of the
Keshwanand Bharti case. He has recorded his accounts, my Lord, what happened. And I think everyone should read that, my Lord. Those, especially, my Lord, those who are waiving the constitution, my Lord, should read the entire, my Lord, it's a 100-page book. What used to happen, my Lord?
And it's very interesting.
Very interesting, my Lord.
Some things we can't share it.
Your Lordship, I also can't share it, my Lord. And therefore, I insist everyone should read that book so that everyone gets the, my Lord, meaning of the real democracy and real separation of powers. And those, my Lord, who are abusing other institutions, my Lord, would know, my Lord, what used to happen. Now, leaving it apart, my Lord, the bench was, my Lord, prima facie of the view that if there is already a power existing to amend the constitution, why should we not permit the parliament to amend the constitution? The power to amend the constitution emanating under Article 368 can also include amending Article 368 itself. Why not? That was an argument, my Lord. An argument was textual argument and quite, my Lord, a catchy argument. Lord, Mr. Palkhiwala, my Lord, it is reported contemporaneously, gave extreme examples and that turned, my Lord, the table. What he said was that suppose Article 368 is so amended that the power to amend the constitution is given to executive. What will you do? Second, India, as per our preamble, is a sovereign democratic republic. Suppose some parliament were to surrender the sovereignty to the Queen of England, what will you do? Democracy would mean adult suffrage. Every adult will have a right to vote. Suppose a parliament comes out with a bill that only a particular section of the people will have a right to vote. Maybe those who are taxpayers or those who are graduates or those who belong to a particular religion. Because in those days, my Lord, that was also one of the consideration when the partition took place. What will you do? So you will have to.
But earlier, prior to the constitution coming into effect, the voting rights were not available to everyone.
To everyone, yes, my Lord.
They were not available.
They were not available to everyone. Yes, my Lord. So these extreme examples were given by Mr. Palkhiwala to convey that you are testing the constitution, not an enactment, an act. Constitution is a very fundamental document based upon which the nation subsists. So extreme examples are necessary to ensure that the constitution withstands any future extreme contingency. My Lord, having said that, my Lord, I'll answer your Lordship's question.
But then your argument that the court cannot interpret the constitution in such a way that it amends the constitution. And what about basic structure doctrine?
It cannot.
No, the basic structure has been brought into only by the judicial interpretation.
Correct.
Otherwise, under 368, there is no such a provision that the no such.
Yes, yes, no, there is no requirement.
Yeah, so
therefore, I'm saying the same thing with your Lordship says.
So your paragraph 45 tries to argue
I'm
that
answering
the
my
courts,
Lord.
that the courts cannot interpret the constitution in such a manner which would amount to amending the constitution. Then the basic structure has been brought out only by judicial interpretation.
I'm sorry, my Lord. I'm not clear to your Lordship. My Lord, I was answering my Lord Justice Narasimha's query. I was not on this. Your Lordships are right. What I said was that even basic structure doctrine came into existence because of extreme examples. That no, everything cannot be amended.
Basic structure first time came in Sajjan Singh.
Justice Mudholkar.
Justice J.R. Mudholkar.
Justice Mudholkar, my lord, your lordship,
In minority judgment,
yes.
Justice Mudholkar and Justice Hidayatullah, they are part of minority. So Justice Mudholkar brought in basic features. If the constitution, if the basic features of the constitution can be changed, then would it not be amounting to changing the constitution?
It's not permissible.
And Justice Hidayatullah said that I would require stronger reasons than given in Shankari Prasad.
He said, I am not a grammarian or something, my lord. That's the expression Mr. Hidayatullah used.
Mr. Hidayatullah said that I would require stronger reasons than given in Shankari Prasad to hold that the Parliament's power to amend the constitution are unbridled.
Yes. But my lord, point is, my lord, that the first time this theory was propounded or the word was coined by Justice Mudholkar. Thereafter, my lord, what point I was making was that it is always on extreme examples that your lordships would interpret the constitution so that it can withstand extreme situations in future. This is, my lord, the basic document of the land. Now, my lord, answering my lord's question, my lord, suppose hypothetically, take for example, my lord, a bill is passed. My lord, normally, nobody would expect that the parliament would pass a law, my lord, surrendering the sovereignty. Parliament would never pass a law that taking away right, etc. But the examples were taken to examine whether such an amending power is there. I am giving a similar, my lord, extreme example. My lord, suppose a legislative assembly passes a bill that in my state, only one language will be used. People will not speak, use or write anything in any other language. Language, my lord, would be within, my lord, list 2. The state has the competence. But it's not necessary that the governor will immediately withhold it or refer it or send it back. He may call upon the chief minister that this will destroy your economy. You do something. For example, some state
You are on timelines now. You are on timelines.
I'm not on timelines. I'm not on time. I'm sorry, my lord, I'm unable to convey myself. I'm not on timelines at all. Forget timelines, my lord. I'm saying your lordship's question was that at the threshold he will withhold. No, it's not necessary that he will withhold at the threshold. He may have a consultative process. He can persuade them. My lord, suppose a part of the bill is repugnant to some central act. So rather than referring it to the president, he might call the chief minister and say that these 2 provisions are problematic. If you agree, I can refer it, I can return it to the house. You correct those 2 provisions. So, my lord, I was only answering your lordship's question that it's not that at the threshold he has to do it. It will have to be after a consultative process and for good reasons. For example, like in Punjab, my lord, he has done it, my lord, for a good reason. So he must have persuaded. And when, my lord, sometimes the political leadership in the state, that is Council of Ministers, have their own limitations, my lord. Irrespective of the party, they have to take a particular stand. There comes, my lord, the wisdom and, my lord, the power of the governor after consultation. If he feels that no, this cannot go ahead, then, my lord, he will have all the 4 options open, and therefore I would not read the power of withhold as a mere power of temporarily suspend his exercise and return it. But again, answering your lordship's last question, that what happens if he sends it and the assembly passes either with some modification, which may have the similar or other new problem, or without modification. Then also he does not lose his power of referring it to the president. They are not mutually exclusive. My lord, for that, would your lordship once again see, my lord, the chart which I have presented? Lord, that may, my lord, assist me, my lord, in making my point clearer. Page 820. My lord, it's in this very compilation, my lords. No, I'll answer, my lord, the first proviso, that it does not exhaust his all options. He can still refer it to the precedent. My lord, but for my satisfaction, please come to, my lord, that chart again. Page 820, my lord, it's in this very volume. For ready reference, my lord, the same chart which I placed, my lord, in a A3 format, my lord, is in a smaller version. The governor shall declare either. Your lordship gets, my lord.
Yes.
First option, grant assent, which, my lord, as I've said, 90% cases it is happening. Withhold assent, second option. And third, reserve the bill for consideration of the precedent. Correct, my lord? Now come to withhold the assent, my lord, apropos, my lord, Justice Narasimha's query. There are two possibilities. At the outset itself, the bill falls through. I'll come to that. My lord, falls through, according to me, is the bill goes. The bill doesn't ceases to exist. But he has an option. Reports resort to the proviso instead of withholding. Bill is returned by the House to the governor with or without modification. Then, my lord, first proviso say he shall not withhold. It doesn't say he shall grant assent. And therefore, he has two options. Either he grants assent or he reserves the bill for consideration of the precedent. My lord, kindly visualize a situation where there is an apparent repugnancy. There is an apparent repugnancy. Normally, it is expected that if there is a repugnancy with the Central Act, the Council of Ministers themselves would say that these two provisions are repugnant and therefore better to take assent of the President of India. That happens. That do happen. The Council also feels that for my state, this is necessary, that I also have a similar provision or contrary provision than the Central Act. So I would refer it to the President. So that can be done. But suppose the council genuinely feels, bona fide feels, that there is no repugnancy. The governor bona fide feels that two provisions or five provisions or any whatever provisions have repugnancy. He resorts to the proviso. Proviso says, now you have resorted to proviso, therefore your withholding option goes. witnesses here.
Mehta, just one
Please, Your Lordship.
information. The entire history of this country, has it ever happened that a bill has been withheld? A declaration has been made by the governor withholding his assent of any bill?
20 times in
No. 20 times it has been
withheld.
withheld.
From 70 till date, 55 years, only 20 times.
Why don't you talk of 50 to 70? Why? You leave 50 to 70.
No.
You talk only from 70 onwards, right?
Lord, it's difficult, my lord, even from 70 onwards, difficult to find out all old records. 70 has no sanctity. So I said that you go back as far back as you can go in terms of collecting the.
20 bills have been declared by the governor to be withheld.
As we understand.
As you understand.
And as has been understood by all governments in past. Only 20.
20 bills.
Only 20.
There was no formal declaration.
No, that is what I'm asking.
No.
Has there been a declaration by the governor?
There is a declaration.
So 20 are those cases where the governor has said that I am going to withhold the bill, or I am not going, let us put it the other way. 20 cases where the governor has said, I will not grant assent for ABC reasons.
No, he would say, I withhold the bill for ABC reasons.
Same expression.
Same expression.
Same thing.
Your lordships are saying in a positive way, I am saying in a negative way. But since declaration is either of the three, he cannot say, I am not granting assent, but he would say, I am withholding. But there is a declaration.
Where is that declaration?
There is a declaration made for all four contingencies. Well, therefore, I was trying to suggest. Therefore, my lord, I was trying to suggest that that felt necessity argument is not, my lord, something, my lord, apart from the time limit. Time limit also, my lord, therefore, I wanted to say that maximum is 1 year, and that also, my lord, about.
Not a thought, but just a doubt.
Yes, my lord.
When the bill is sent back with the message, I think parliamentarians will be able to tell us better. When a bill is sent back with a message, and then the assembly amends it and in entirety of it, completely new sections are added, altogether completely changed, and then comes back. Under the parliamentary procedure, does it continue to be bearing the same number as a bill, or is it a new bill?
Same number.
Same number. So therefore,
I
comes back,
will not go by my learned friend's experience, but
Same
I
back.
will check up and answer, my lord, so far as I am
when
concerned.
it comes back, then is it, even in a case where the completely act is changed, is it a case where only the proviso will apply?
My lord, in Tamil Nadu, it was a separate number.
Normally, it would not happen, my lord. I mean, that's again a hypothetical.
Principle, as a principle, so it comes into the hands of the governor as a new bill,
No, same bill.
same bill, even if it is completely
Yes,
changed.
But
even
I
it's the
will
same.
answer.
Only a
The
question.
bill is exactly the same, my lord.
No, bill.
Because a new bill would be to withdraw that bill and introduce another bill. That's how it's a new.
Therefore,
No.
But
I'm
that
sorry.
bill, the number doesn't change, my lord. So we've done it several times.
No, my lord, subject to correction in case of Tamil Nadu, and I'm not going into the facts, when it was returned and when it came back in a new number or possibly the old number. I'll just check up and answer, my lord. I don't wish to hazard. my lord.
In my experience, my lord,
Not just an.
No, I go by
If I had
my friend's experience, my lord. I don't have first-hand experience, but I'll take instructions, my lord, if there is anything.
and I've never heard, my lord, we never get a message that I'm withholding the bill. At least that declaration I've never seen.
Therefore, I ask this
No.
question.
I'm sorry.
The governor is sitting over it and he
I've
withholding.
never
He
seen.
may be withholding, or he makes a declaration
Yes,
that I'm
it is
withholding it.
not part of any record that any formal declaration is made, at least.
Just like a declaration made to
Well,
grant.
sorry,
assent,
but
is there a
sorry.
declaration to?
No, he just sends it back. He just sends, there is no declaration. The act itself is a declaration.
Lord, my learned friend is, my lord, misconstruing my submission. He says, I have never seen that bill is returned to us. First of all, Parliament is never sent that bill. It is the Assembly. Number two, Assembly is also never sent the bill that I withhold it. So he withholds, that's all.
Withholding has to be done by the governor, not by the assembly.
Exactly, that's what my learned friend says, parliament never
and
come to
even the
know
president sends
that-
back the bill with the message. It's not, it's the same thing, but there's no formal declaration is what I'm saying.
No, that
My lord
is-
asked that question, I answered.
That's the
The act itself
constitutional
is-
requirement. Declaration is the constitutional requirement. You
Just-
have to declare.
Yes, well, just one clarification. If the bill comes back and if there is no amendment made and the same bill is sent back, it will come back as the old bill. If any amendments are made, well, I'll reconfirm this tomorrow, but if my understanding.
When the bill comes back, the language, that's why the constitution has used different kind of expression. When the bill comes back, it comes with a request, with a message,
Correct.
requesting the house to reconsider.
That's correct.
So the message will have a reason.
Correct.
Message
Yes.
will have a reason. Based upon that, the house will reconsider.
Yeah, exactly.
He shall declare and request with a message are two different kind of expressions used in the
So if
Your
the
lordships are
message-
right.
but if the
Both
message-
will have to coexist.
But if the message is considered favorably by the house and the house makes amendments, then it might come back as a fresh bill before.
As a new number.
I'll confirm it tomorrow.
But I will also confirm, my lord, I don't want to hazard guesswork, my lord. I will confirm, my lord, but possibly it goes as a separate bill or with a message that we have not considered the suggestion or we have considered partly or we have completely changed the bill or whatever, my lord. I'll check up, my lord. There must be
I
something.
don't want to interrupt. Sometimes happens, Malad, the Lok Sabha sends it to the Rajya Sabha. It's not a money bill, Malad. We send it back with suggestions. And then the Lok Sabha sends it back. It's not a new bill. We've experienced it so often, Malad.
Quite
Because those, it's not a new bill, that's all. Maybe, Malad, that the assembly here is different, I don't know. But that's our experience.
The amendment is carried out pursuant to a message.
Better to take instructions rather than argue.
Conduct of business rules will tell us.
Yes,
That's right. That's always.
yes, please.
Parliamentarian on your side.
No, Manoj.
There is.
We are all only lawyers.
Then send money.
There's a parliamentarian.
There is.
Yes. But he was a parliamentarian.
Mahesh Jetmalani was a parliamentarian.
Yes, yeah. Experience.
I can begin tomorrow, Manoj.
Take the time between you and the learned attorney
Look, we will,
by 1 o'clock.
I'll at least take an hour.
Huh?
I'll at least take an hour.
No, we'll conclude by 1 o'clock. So you decide amongst yourselves.
I'll ensure that he gets, Manoj, his time. There is no, we will act in a collaborative and
You
consultative.
act in a collaborative, consultative.
And I am bound by his aid and advice.
And he will be a guide, philosopher and friend.
Therefore, I am saying, Manoj, I am bound by his aid and advice. And he is a dual role, friend, philosopher and guide, both, Manoj.
My application
Then
should be
can you
formally
put that-
taken on record. My intervening application has to be formally taken on record.
Has been withheld.
Yes, pardon, Manoj?
Get one of the declarations made by the governor where a bill has been
Has to be
withheld.
allowed, Malad.
I'll try and get
You
it.
try and
Because-
let us see if there is something.
Yeah, it's possible.
Yes.
Very good.